Well, hello everyone, and welcome to Uncivil Law for a special Friday night discount show where we will do the Wish.com version of Friday Night Frenzy. Rob, our good friend and yours, has had a rough week and has to get ready for many things, and so he doesn't want to do the Friday Night Frenzy tonight, but that's okay. I am here to provide you some fun and frivolity, and I've been doing some research in the background, finding some good and fun stories, and I hope everything is great. All that good stuff. And Rob is running late because Rob is gonna rob. Okay, so that's where we are sitting with all of that. So let's see what's going on over on his channel. Oh, Emily D. Baker dropped on. Okay. Oh, Lord. All right. All right, let's go ahead and cover some stories while we're waiting. We're going to be here for a while. Let's start in Italy, where apparently Italian mom has lost the last bit of her patience and said that we are going to kick her own grown sons out of the house. So apparently Italian mom has lost her patience and won about to evict her own parasitic grown sons from her home. So no love lost in Italy. I saw this story and I thought that was fun. So let's go ahead and read this story. An Italian mother has lost her patience with her grown-up sons, who she says are freeloaders, and won the somewhat unusual case in Italy to have the pair of what she described as parasites evicted from her home. How fun. The plaintiff, identified only as a 75-year-old retiree living in Pava, had filed a lawsuit in court accusing her sons, age 40 and 42, of overstaying their welcome. Apparently Italy mom lost her patience. I guess they have to leave the nest sometime, and now's as good a time as any. According to the complaint, both grown men, who the disgruntled parent labeled as parasites in the court filing, are employed, but are living in her apartment rent-free. So they don't pay rent, they don't help with the bills, they just take from their poor Italian mother. The Italian mother is separated from her husband and lives off of her own pension, all of which apparently goes towards home upkeep and food, including her sons. So she's trying to pay for her sons. All those Italian home cooked meals, gonna take up some expenses there. The duo of moochers have not been contributing financial or even helping around the house with chores, according to the lawsuit. No pay, no rent, no help with utilities, not doing chores, no nothing, ma'am. No nothing. The judge, Simona Cabri, sided with the mother, ruling this week that the sons, whom she mocked as bambosini, or big babies, have until December the 18th to move out of the mom's apartment. The judge saying, quote, "There's no provision in legislation which attributes to adult children the unconditional right to remain in the home exclusively owned by the parents against their will and by virtue of the family bond alone. Not for nothing, of course, but this would come out the same in American law." I can't speak to the finer points of Italian law, but apparently even Italy has its limits. In Italy, apparently it's common and culturally acceptable for grown children in their 30s to still be living with their parents. So I guess that, commitment till 18 is a little bit more rich in the Italian community, I guess. The practice of lingering in the family home well into adulthood is especially common among men who are dubbed mamonini, or mama's boys. I don't know how that plays into meeting the Italian women, to be honest. If you bring the Italian women home, for dates and stuff, I'm not sure how that works, but okay. Armed with the knowledge, the woman's son had lawyered up and countersued their mother to stop them from evicting them, arguing that Italian parents are obligated to maintain support for their children as long as needed. So they countersued, arguing, I suppose, for child support, I guess, for lack of a better description, into their 40s. I mean, okay. I don't know, man. In this decision issued Tuesday, the judge acknowledged existing law, but argued it no longer appears justifiable, considering the two defendants are over 40. And once a certain age has been exceeded, the child can no longer expect the parents to continue to maintain an obligation beyond limits that are no longer reasonable. So apparently, there was some case law that apparently stood for the proposition that the parent has an ongoing obligation, apparently forever, to maintain their children. So I guess those Italian romances are really costly. Forget about child support till you're 18. How about child support forever? And apparently the attorneys for the sons are contemplating appeal because apparently there's some kind of case law. I believe Italy is a civil law system though, so that wouldn't work the same under common law. But they say there's just no legislation about it. So I guess they're just ignoring the precedent, which, in the civil law system is something that you much more are readily able to do. So, okay. So that's what's going on in Italy. Apparently there was some precedent standing for the proposition that mama's boys can stay at the house forever and mama can't stop them. But, well, apparently this mother does. So I suppose there's some relief for the Italian mothers there somewhere. Okay. Let us do another story. We should have a poll in chat. When will Rob end his stream? Now I'd like to note for the record, he told me that he would end his stream at 10:30 Eastern, 9:30 Central, which was 23 minutes ago. So when will Rob actually end his stream and send things my way? That is the question. So put your answers in chat. Just give me what time do you think Rob will actually end his stream? 2 hours? That's probably a reasonable bet, Kestrel. 28 more minutes? I don't know, man. Midnight, 10:30? It's already 10:30 Eastern. It's 10:53. 45 minutes? 12? 11:30 after midnight? 11:32? I think Rob forgot that he said that he would end his stream, at a certain time. Yeah, 3 hours. Yeah, I think that's yeah, exactly. They're powering on over there. That's fine. All right, let's cover another story while we're waiting. This is pretty interesting, relating to whether or not troops, as they are being court-martialed, have the right to unanimous verdicts. You may not have known that in the military you don't need a unanimous verdict to convict, except, of course, in a death penalty case. But for a typical case, you don't need unanimous verdicts. And you didn't need unanimous verdicts in non-military cases until what? 4 years ago or something, when the United States decided Ramos versus Louisiana and said, yeah, unanimous verdicts are a good thing. So there was actually no requirement until very recently that civilian convictions have to be unanimous. Now, we still don't know how many members have to be on a jury, incidentally. That still has not been decided. But whatever number we need, they have to be unanimous. All right? So the question about this is, does this rule for the civilians apply to the military and their court-martials, which incidentally can include prison time just as long as any civil system, right? So you can be tried for murder within the military, you can be tried for robbery within the military, you can be tried for any number of crimes that are military, but if you are tried within the court-martial system, your conviction doesn't have to be unanimous. So there is some potential expectation The Supreme Court might get involved in this. I don't think they will, incidentally, but you never know. I could be surprised. But I don't think they will get involved. I think they'll probably keep it the way it is and let Congress decide. But yeah, the law in the military is different than the law in the civilian system. Yeah. And the UCMJ has its own code from Congress, right? The entire UCMJ, as I'm sure you're well aware, is an act of Congress because Congress passed the UCMJ in its many manifestations. The UCMJ is very different from normal court. It is in a lot of ways. This is very true. So let us read this article and learn a little bit more about what's going on. So this is coming out a result of the Air Force. An airman is asking the Supreme Court to consider the question whether service members have the right to unanimous jury verdicts in general court-martials. The top military court, the Court of Appeals for the Armed Forces, which is the top military court. So you go from the Court of Appeals for the Air Force, and then if you want to go beyond that, you go to the Court of Appeals for the Armed Forces, and that's typically where your ride stops. The Court of Appeals for the Armed Forces decided 5-0 in a ruling in June that service members are not entitled to unanimous verdicts, confirming a service member can be convicted and sentenced to prison time, even if up to a quarter of the jury believes them not to be guilty, because the rule is typically 3/4. So, yeah. So that would be 9, right? 9 members of 12. So you can have 3 people vote not guilty, and you're still guilty if you have a 12-member jury. The Air Force Master Sergeant, so fairly high ranked for an enlisted person, filed the petition on Monday, which could potentially open the door for the nation's higher court to overturn this century-long legal precedent in the military legal system. The petition presents to the Supreme Court an important issue of constitutional law that affects millions of Americans, and we're hopeful the court will agree to review the decision of the Court of Appeals for the Armed Forces, says the airman's lawyer. E7? Yeah, I knew it was pretty high up there. Couldn't remember exactly where it was, but yeah, it's like, yeah, E7's pretty high up the enlisted ranks, right? Yeah. A general court martial in 2020 convicted the master sergeant of 2 specifications of attempted abuse of a child for sending lewd messages and photos to Sarah, who was a fake 13-year-old girl created by the Air Force Office of Special Investigations. So he tried, attempted solicitation of a minor. So they thought this was a bad guy. They faked a 13-year-old. They got him soliciting the 13-year-old. And yeah, Anderson apparently also sent separate messages to a real 15-year-old asking her for some sort of contact for which he wasn't charged, according to the lower court summary of the case. So there was so maybe that's where that came into being, right? This guy is contacting a 15-year-old. Somehow the Air Force becomes aware of that. For whatever reason, they want to do a sting because maybe there's some sort of problem with the case, which, that can happen for any number of reasons, which, you don't have to think about it real hard to think about why that could be a problem or where something could go wrong, right? But they're like, okay, so we think that this guy has this proclivity. We can't charge him for the 15-year-old for whatever reason. So we're going to manufacture a 13-year-old and try to get him to solicit her. And then he does. Huzzah. Right? So we've got our trap set and him caught. Before trial, Anderson asked the military judge to require a unanimous verdict, or at least make the jury divulge whether it reached a unanimous verdict, but the judge declined. So he doesn't even know what the verdict is, whether it's unanimous or not. So all that stuff. Yeah. Nikki says, so he got charged with the pretend victim, but not the real one? TF. Yeah, as I said just now, there might be any number of reasons that he can't be charged for the real one. You can imagine something went wrong somewhere along the way with the evidence or some other problem. So for whatever reason, apparently they weren't able to charge him. Maybe they found the information in an illegal way. Maybe there was some other problem. Maybe the messages were a little ambiguous. Maybe whatever, right? I don't know what the situation is. But for whatever reason, they couldn't charge him for the 15-year-old. The facts were muddy. The evidence was obtained illegally. Some other problem. The 15-year-old girl couldn't be found to be a witness, or she refused to be a witness. Who knows, right? Who knows what went wrong? But something went wrong. It happens. So they manufacture a 13-year-old so that they don't have the problem because they have a clean case because it's manufactured. It happens. That's what's going on. Anderson unsuccessfully appealed his case to the Air Force Court of Criminal Appeals, and then, of course, the Court of Appeals for the Armed Forces, which isn't that entrapment? No, it's not. No, that is not entrapment. Entrapment, the short definition of entrapment, is when the police coerce you into doing something you wouldn't otherwise do, not merely trick you, right? Because the police are allowed to lie, right? The old sort of standby of the police officer dressed up as a woman of the night, right? And solicits Johns, right? You want a good time, baby? I'll give you a good time, but it's really a police officer. No, it's not entrapment because they are not coercing you. They are providing you an opportunity to engage in behavior that by your natural proclivity, you apparently are willing to engage in. They're simply providing you an avenue to engage in actions that you want to engage in, right? They're not coercing you. They're not forcing you. They're simply providing you the opportunity. That is not entrapment. So no, it is not entrapment. So no problem. Yeah. But good question. The police are allowed to lie to you. The police are allowed to lie. They can't coerce you. They can't force you. There is a legal difference. In the civilian system, of course, even where one juror dissents, the defendant gets a new trial, but not so in the military because they didn't adopt that rule. Tina says, I thought they could poll the jury. They can in the civilian system, but apparently not in the military. They can't poll a jury, apparently, in the military. So I don't know what to tell you, but apparently that's the rule. An accused service member who goes to a court martial typically gets 6 to 8 members to hear their case instead of 12. I believe 12 is required for death penalty cases under the UCMJ. There's also the worry the requirement for unanimous verdicts could lead to higher ranking jury members putting pressure on lower ranking peers in the deliberation room, although I'm not sure how that's any less a concern now than it would be then, to be honest, but okay. But they are under orders not to let rank influence decisions. You can't pull rank in the jury room. King, for their part, says he finds it unfair service members don't have the right to unanimous verdicts. I mean, it is an aberration from the rest of the law, that's for sure. Anderson's petition to the Supreme Court relies on the Sixth Amendment, which provides a right to an impartial trial, and Fifth Amendment, which provides rights of due process. Anderson saying the unanimity requirement is crucial for ensuring a guilty verdict only results from a fair proceeding. But the Supreme Court typically, and I think likely here, repeatedly relies on the principle that court-martials are fundamentally different from civilian trials. The Supreme Court precedent says Sixth Amendment doesn't apply in the military system. Which, yeah. Non-unanimous verdicts have been a feature of the military justice system since the country's founding as well. Of course, Congress always could change it by congressional act, because it is Congress's military, right? It is Congress's military. So Congress can say what the military is or is not allowed to do and say what orders are lawful or not lawful and all kinds of stuff, right? So yeah, it's like, yeah, it's a good thing. As part of a House bill, lawmakers are pushing the Pentagon to provide information on how it would implement unanimous verdicts, which, implementing would be pretty easy, just give different instructions, and associated costs. Both the House and Senate have passed versions of the bill, but the two chambers must negotiate on the differences. A retired Air Force colonel who served as the service's chief prosecutor previously told the Military Times the lack of guarantee to unanimous verdicts erodes confidence in the military justice system. So at least one person thinks that they should change it here. And then, of course, it is noted, which is quite true, that the Supreme Court only hears about 80 cases, despite receiving 7,000 to 8,000 petitions, and very, very rarely on questions of military law. So I think the odds do not favor the airman. I wouldn't get his hopes up, but yeah. Are we discussing a particular branch of the military? Not in this respect, no. These rules are relatively uniform because it's the UCMJ, the Uniform Code of Military Justice. So there is nothing special about the Air Force. It just happens to be coming from the Air Force in this particular instance. So that is what is going on there. All right. Let's cover another story. It's now 10:06, by the way. Rob looks like he is going strong with no end in sight. All right, let's do something else. Melissa says there's nothing special about the Air Force. Not within the context we're talking about, no. There's nothing special about the Air Force versus the Navy versus the Marines versus the Army versus the Coast Guard versus Space Force. No. There's nothing special about the Air Force in this context. It's a uniform code of military justice. There's nothing special about the Air Force within the broader context of the military. In this context, there's nothing special about it. There's no special rule for the Air Force. So, Brian Laundrie's lawyer may be forced to answer questions about the murder of Gabby Petito, as this case somehow continues to go on, despite my expectations. I personally would have dismissed this case long ago as the judge, but I'm not the judge. And I'm getting constantly surprised by this case. I did not think this cause of action was very good. For those of you who are unfamiliar, right? Brian Laundrie killed Gabby Petito. That is bad. Murder is bad. Don't do the murder. Brian Laundrie's parents then sued, Gabby Petito's parents sued Brian Laundrie's parents for a whole bunch of stuff, which I didn't think any of them were good causes of action. I didn't think it made any sense. And I thought their complaint didn't make any sense. And I thought it should have been dismissed out of the gate. Right? They sued for intentional infliction of emotional distress. Okay? Against the parents. Because the parents had said, we hope you find your daughter safe or something. And this apparently is a comment that is so vile that no reasonable person should be required to tolerate it. I don't know, man. I didn't really see it, but I'm not the judge. So I don't know what's going on to that one. Anyways, so the lawyer also got sued as part of this because he was the one that made the statement. Right? The parents didn't actually make the statement themselves. The lawyer did, but on their behalf. And so the lawyer is their agent, respondeat superior, blah, 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 blah. So, yeah. All right. So let's learn a little bit more about what's going on here. Lawyers for the parents of Gabby Petito say they want to hear from the attorney of the parents of the boyfriend of Brian Laundrie. Okay? Because we're suing the parents of the Brian Laundrie because the parents did an intentional infliction of emotional distress, apparently, and the attorney also did an intentional infliction of emotional distress because he was the one who said the message about hope your daughter is found safe. And apparently at a time when it's argued the parents knew that they were dead. But even if they knew that the daughter was dead, I still don't think the statement is intentional infliction of emotional distress. Hope your daughter comes home safe does not strike me as a statement beyond the pale. But that's just me. I don't get it. Anyways, Joseph Petito and Nicole Schmidt, Gabby Petito's parents, sued Christopher Laundrie and Roberta Laundrie, alleging that Brian Laundrie had told his parents he killed his girlfriend, so they knew that she was dead, because otherwise this doesn't work as a theory at all. And not only didn't share this information with the Petitos, they tried to make arrangements for their son to leave the country. Well, that's not what they're being sued for. They're not being sued accessory to wrongful death, right? They're being sued for intentional infliction of emotional distress. Somehow. Yeah. As to not sharing information, they're under no obligation to share the information. You can't sue them for not sharing information with you because you're not entitled to the information as a matter of law, right? Them keeping their mouth shut is not something you can sue for. Everyone has the right to remain silent. So you can't sue them for keeping their mouth shut. So you sue them for saying, we hope you find your daughter safe, because they knew, the argument goes, that the daughter was dead. That statement is cruel. I don't know. This particular motion, which seeks to force the Laundrie's lawyer, whose name is Stephen Bertilno, to testify about the conversations he had with Brian Laundrie, as this continues to get just more, complicated in the fact pattern, says that both the Laundries and the attorney knew that Gabby Petito had died and knew the location of her body at the time the statement was issued by the defendants, in which defendants expressed hope that she would be reunited with her family. Which I've pointed out this before. Like, I'm be willing to bet that basically everyone was telling Gabby Petito's parents some version of, we really hope that you'll find your daughter and hope that you'll be reunited. And somehow it doesn't click to me, and maybe it's just me, but somehow it doesn't click to me that their parents saying basically the exact same thing everyone else is saying is somehow cruel because they know that the daughter is dead. Because IIAD is all about the impact on the listener, right? It's a statement that when heard or listened to is a statement so vile that no reasonable person should be expected to bear it. But they're not communicating anything other than the overt message, which is the same overt message everyone else is hearing, or saying rather. So I don't know how their own subjective knowledge, which of course the Petitos don't know. They don't know what's in the Laundrie's head. How can they? So I don't know how the Laundrie's subjective knowledge makes the statement on its surface somehow cruel when it's heard. I don't get it. I don't get it. I don't understand it, but that's where we're at. The motion comes after Christopher Laundrie and Roberta Laundrie gave their depositions on the 10th and 11th, during which they waived their privilege between themselves and the attorney. So that solves that attorney-client privilege problem. And the attorney's deposition, Brian Laundrie's father told the lawyers that he had spoken with his son in late August and relayed the contents of that conversation to the attorney, testimony that was largely corroborated. So the parents waived privilege with the attorney, and I suppose will be waiving privilege on behalf of their deceased son, I guess. Privilege does survive death, but of course, as the heirs to their son, they would be in a position to waive the privilege because the privilege now belongs to them, I guess. During the attorney's deposition, he testified that Christopher Laundrie advised him that he had spoken with Brian Laundrie, and Brian Laundrie was frantic, stated that Gabby Petito was gone, and further requested his parents obtain a lawyer. So, I suppose we've now successfully proven at the time they gave the statement, they knew Petito was dead. I just don't get it. I don't get it. Okay, unlike the Laundries, however, the attorney asserted attorney-client privilege regarding his conversation with Brian Laundrie. And refused to disclose any information he learned from Brian Laundrie. The motion argues that Brian Laundrie's suicide and notebook he left behind, which confesses killing Petito, amounts to waiver of privilege, which it absolutely does not. It doesn't go to his conversations, right? The binder's not privileged, but the communications are still privileged. I don't get it. Clearly, Brian Laundrie has no expectation of privacy in authorizing a confession and leaving his backpack to be found. Okay, as to the confession in his backpack, I agree. But that doesn't waive privilege. Right? That doesn't waive privilege as to what he told the attorney. Presumably, Brian Laundrie's estate can waive the privilege, but that apparently hasn't happened. The motion argues that because Brian Laundrie waived the privilege, which I don't think he did, the attorney can assert it, which I think he can. The lawyers for Petito parents also contend the attorney wasn't asserting privilege on behalf of his client, as the law allows, but instead on his own behalf in an effort to keep him testifying about what he knew at the time he made the statement. So we're having an argument about whether or not they waived privilege, which I don't think they did. So that is my thought on the issue somehow on all this, but so they're filing a motion on all that. Good times. We're now 45 minutes into Rob time for those of you keeping track at home. Okay. All right, let's do another one. This one is disturbing. This kind of thing happens with some kind of frequency, but it's just one story among many, unfortunately. But a reminder, when you take your devices places to get them repaired, they will look through your device for naughty pictures. So just a reminder, it happens a lot. And the tech people will absolutely look for your naughty photos. This guy did take it one step further, however. A T-Mobile employee who, you know, people went to with their phones because they weren't working, can you help me, took advantage of this opportunity to pull hundreds of nude photos from his customers' phones and post them to the dark web. So, yeah. So there's that. So this kind of story does happen from time to time. Usually they don't post them. That aspect is new, but you'll see that, you know, that the Best Buy guy or, you know, whomever, what computer repair store gets noted for seeing your dirty photos. So it happens kind of a lot. But this guy has gotten busted for posting them to the dark web. So the T-Mobile employee from my home state of South Carolina is facing criminal charges and now faces a civil lawsuit alleging he shared nude photos on the dark web for chat forums and gaming websites by accessing customer passcodes because, you know, the customer told them, and texting himself hundreds of compromising photos. James 229 was arrested in Beaufort County. That's in the nice low country in South Carolina. I lived in Beaufort for a little while. It's really beautiful down there. I really like it. Very calm, pluff mud. You got the grass right up in the sand dunes. You know, you get that grass right up to the water line. Palmetto trees. Really beautiful part of the state. Good shrimp. Recommended. Anyways, a man and his wife, identified in pleadings as Jane Doe, filed a lawsuit against Mr. Two last week. The lawsuit also names T-Mobile as a defendant. T-Mobile, for their part, says we take this very seriously and move to address the unacceptable activity, saying they worked closely with an authorized retailer who took action to terminate the employee, which, very exciting. The lawsuit, yeah, a lot of Forrest Gump, I think, was shot in Beaufort. I believe, because, it's beautiful down there. The lawsuit alleges two accused accessed the women's photos on May the 18th of 2020 when the couple entered a T-Mobile store in Beaufort to buy a new phone. Two told the husband he could leave, and when he returned, he'd have the phone ready within an hour. The husband returned to collect his phones and left. After opening the phone, he noticed forwarded text messages from his phone number to a number he didn't recognize. That's sloppy, man. He didn't delete the evidence of him forwarding the messages. That's just sloppy. When he realized that the messages were forwarding private photos of his wife and child, he called the forward number, and two answered while on the job in the store. The husband apparently returned to T-Mobile and approached Mr. Two. He looked through Two's mobile device and found that he had forwarded multiple messages with photos of his wife, some of which showed her in various stages of disrobe. There are also photos of her in a bathtub bathing their minor daughter. Good times, Good times. Two has files of numerous compromising photographs of other women on his phone, because of course he did. His phone contained a folder of hidden photos, which contained hundreds of compromising photos of other women. Two, of course, obtained these photos by accessing mobile device left in his trust with him at the store. After the customers provide their passcodes based on the representations that he made. The services, by their nature, involve handling and transferring of private, confidential, and sensitive data, because of course they do. Security footage shows Two openly and casually scrolling through the various mobile devices that were left with him. The lawsuit says the T-Mobile defendants have a duty to customers and invitees to exercise reasonable care in maintaining the premises. We're going to try this from a premises liability angle. I don't know if that works as a premises liability angle, but it's an interesting idea. This includes prevention of invasion of privacy and theft of private employee of its employers. You could just do respondeat superior here, by the way. The agent is acting in the course of their employment of the employer. So I'm not sure premises liability works, but sure, throw it into the mix. Similar incursions of invasion of privacy regarding T-Mobile have also been reported, but of course this isn't just a T-Mobile problem. By the way, this is a broader problem because, people are people. Apparently, the lawsuit also alleges that T-Mobile took possession of a chip from the phone and destroyed the chip. So, preventing further forensic examination of data that could have been stored on the chip. The lawsuit saying that Two's conduct was so extreme and outrageous as to exceed all possible bounds of decency and must be regarded as atrocious. IIED? Okay. Yeah, intentional infliction of emotional distress. That's intentional infliction of emotional distress language. So I was like, we're going to try IIED too? Okay, that works. The lawsuit alleges negligence and invasion of privacy, among other causes of action, I think. It seeks an undisclosed amount for all this stuff. Two also has a criminal case pending, whose public defender did not immediately respond to the request for comments. Yeah. All right, let's see what else we got going on. Thank you for the 161 of you currently tuning in to be with us tonight as we patiently read some stories. Let's spend a little bit of time talking about some of the cases the Supreme Court is going to be hearing in November. There's some good stuff coming on. Let's do a little Supreme Court preview. Of some of the stuff coming on at the U.S. Supreme Court. You guys love the U.S. Supreme Court. I love the U.S. Supreme Court. Let's take a look at some of the cases that will be being decided in November, or being heard in November, I should say, not decided in November, but yeah, some of the cases being heard. All right. So here are some of the cases that are being heard in November. The justices kick off November's argument session with Coley versus Marshall, a case that began as a lawsuit between two Alabama women. Both women's cars were being used by someone else when the police pulled over the drivers, found drugs, and seized the car. Civil asset forfeiture, sounds like to me, right? Yeah. So the police seized the car as basically drug paraphernalia. After more than a year, the women eventually got their cars back, but although during that time, one of the women was unable to find work and fell behind on her bills. They filed lawsuits in federal court where they allege that failure of the state and local governments to provide them with a prompt hearing after their cars were taken violated their constitutional right to due process. So that is certainly an issue, to be sure, because their cars were just being held for so long, apparently without a hearing. As the case comes to the Supreme Court, the dispute, at least in part, is about what test the court should use to determine whether these individuals are entitled to a hearing to challenge the government's retention of property while they wait for a final decision on whether or not they'll lose the car. The women contend the court should apply a three-part test outlined in the court's 1976 decision of Matthews versus Eldridge, which looks at the private interest involved, the risk the individuals be wrongly deprived of that interest under procedure, as well as the value of additional procedures to safeguard their interest. The government contends for its part that they're only required to provide a timely forfeiture proceeding, and the correct test to be determined whether that occurs is one where the speedy trial is determined, which determines the length of the delay and the reason for the delay, as well as whether or not the individual asserts their right to a speedy trial. So a difference of some tests on the issue. Two local governments argue the women do not have a legal right to sue because they, rather than local governments or the state, were responsible for the delay. Among other things, the local government notes the women could have posted a bond to get their cars back but chose not to. They also waited a year to file a motion seeking return their cars on the ground that they were innocent owners. So basically trying to say they waited too long and allowed their cases to get delayed. Yeah. We are now officially an hour over time. All right. This one is really, really interesting. 2021, the justices considered a petition followed by President Trump asking them to review a ruling by a lower court that Trump violated the First Amendment when he blocked some agencies. So you may remember this issue, right? Trump blocked people on Twitter, and you may remember that various people on the left went crazy when Trump blocked people on Twitter. And it's like, you can't do that. You can't block people. And then, of course, what happened? A lot of those same people on the left then blocked people because, of course, they did, right? So you'll remember that issue. Or you may remember that issue with Trump blocking people and being like, you can't do that. You can't block people. And so this issue has percolated once again. The justices sent that case back with a decision to dismiss because by that point, Trump was no longer president and the case was moot. But the issue has resurfaced on the issue of when public officials are acting as governmental officials in their social media. And when they are acting as social media, what they can do about it. All that stuff. So, yeah. The cases are only the first of some cases involving social media. Next year, they're also going to hear cases involving the degree to which the government can force social media companies to post content that disagrees with the social media company's viewpoints. A case I think is very, very interesting. Didn't Twitter block Trump? Yes, but that was private action, right? So when Twitter blocked Trump, that arguably was private action. When Trump was blocking people on Twitter, the argument was that that's public action because he was the president. So that's the difference. In the first case that they're hearing in November, the justices are reviewing a ruling by the U.S. Court of Appeals for the Ninth Circuit, which we haven't done SBF yet because I've been waiting patiently for Rob to finish because I didn't want other people to miss it. Well, I've been waiting patiently to do SBF because I'm nice. In the first case, O'Connor, Ratcliffe versus Garner, the justices are reviewing the ruling by the U.S. Court of Appeals for the Ninth Circuit, which held that two members of the Southern California School Board violated the First Amendment when they blocked two parents who criticized them on their personal Facebook and Twitter accounts. So this is part of the issue, at least in part. Are these governmental accounts? Are these personal accounts? Blocking them? What is going on there? The second case, Linkty versus Fried, pits Kevin Linke, a resident of Michigan, against James Fried, a city manager. Linke didn't approve of Fried's handling of the pandemic and left critical comments on Fried's Facebook page, causing Fried to block him. Linke went to court when he argued that blocking him violated the First Amendment, but the U.S. Court of the Sixth Appeals rejected the argument, holding that because Fried didn't operate his Facebook page as part of his duties as the city manager, there is no First Amendment violation. So we get into this issue of when is it governmental speech versus when is it personal speech? Is it merely if it's Donald Trump's account, for example, does that inherently make it governmental speech or not? Does the actions that he do make them governmental or not? How exactly does that work? So there's a lot of really interesting complications there for sure. So that's certainly a case to watch. But the one coming up next year with the social media blocking and the degree to which they can do social media blocking, the degree to which social media companies can prevent certain viewpoints from being expressed is an interesting issue. And I think the Fifth Circuit Court of Appeals analysis was really persuasive. And so I'm very interested to see how they deal with that. I'm very interested to see if they agree or disagree on that issue. It'll be interesting for sure. All right, so then in trademark law, during his bid for the Republican presidential nomination in 2016, Senator Marco Rubio of Florida claimed that then candidate Trump had small hands. The claim spurred Steve Elster to try to register the phrase Trump too small so he could print and sell t-shirts bearing the phrase. Elster said the phrase was intended to convey that some features of President Trump and his policies are diminutive. Cute. On November the 1st, the justices will weigh in the dispute when the trademark office denied his trademark rights to file the application. The relevant law bars registration of a trademark that uses the name of another living person unless that person gives permission. So Trump is certainly a living person, so yeah. The U.S. Court of Appeals for the Federal Circuit disagreed and ruled for Elster, concluding that barring Elster from registering Trump too small phrase would violate the First Amendment. The government, the Court of Appeals reason, does not have an interest in restricting speech critical of the government officials or public figures through trademarks. I'm going to just let Rob know that we're still waiting. I don't know what I should say to Rob. I don't know if I should say anything to Rob or not. Maybe I won't say anything to Rob. Anyways. All right. So in federal loans and the Fair Credit Reporting Act, Department of Agriculture Rural Housing versus Kurtz, the justices will decide whether Congress waived the United States sovereign immunity for lawsuits that arise from the Fair Credit Reporting Act. The case was filed in federal court under 2020 by Reginald Kurtz, who claims that although he no longer owed anything on a loan made to him by the Department of Agriculture, the department damaged his credit score by reporting that his account was past due. Kurtz notified TransUnion, the credit union, that the report was inaccurate, but the USDA did not correct the report. Kurtz says this violates the Fair Credit Reporting Act, which among other things requires anyone who provides dispute information to credit reporting industries to investigate it and, if necessary, correct it. The USDA, for its part, asked the court to dismiss the case, arguing, and the district court agreeing, the Fair Credit Reporting Act did not show that Congress had intended to waive sovereign immunity with respect to lawsuits against the government, so the federal government can break the FCRA as much as they want. The Court of Appeals for the Third Circuit reversed, emphasizing that the law allows lawsuits against any person who does not comply with the law's requirements, and defines the term person to include any government or governmental subdivision or agency, which seems pretty clear to me. Moreover, because the federal government is the country's largest employer and creditor, the Court of Appeals reason allowing it to be sued would be consistent with the goals. Well, it seems pretty clear to my mind as well. Yeah. I guess I'll just try to, I'll just ask him, any ETA? I'll just say, well, I'll text him. I'll do that. I'll text him instead of chatting with him. All right. The Second Amendment returns to the Supreme Court, although I think this is going to be a nothing burger, and perhaps even more so due to the recent events in Maine, but I thought it was going to be a nothing burger beforehand as well, to be quite honest. Less than 2 years after New York Pistol and Rifle Association was struck down New York's gun licensing scheme, the justices will hear another gun rights case, United States versus Ramini, a challenge to the constitutionality of a federal ban on the possession of guns by individuals who are subject to domestic violence restraining orders. I don't think this case is going anywhere. I imagine it's going to be punted on alternative grounds. So, all that good stuff. The person, Zachary Ramini, was involved in 5 shootings in December 2020 and January 2021, including one incident in which he was involved in a car accident and shot at a driver of another car, and another in which he fired in the air after his credit card was declined at a fast food restaurant. So maybe not a guy who we want to have a firearm, to be honest. When police identified Ramini as a suspect and obtained a warrant to search his home, they found a rifle and a pistol. Because Ramini had been subject to a protective order after the alleged assault of his former girlfriend, he was barred by federal law from possessing a firearm. Ramini has asked the court to dismiss the indictment, arguing the law violates the Second Amendment, but the federal district court and a panel of the United States Court of Appeals initially upheld the law, rejecting the challenge. But after the Supreme Court's decision in Bruin, Ramini, I guess it's Ramini, not Ramini, Ramini, the panel issued a new opinion vacating Ramini's conviction and deeming the statute unconstitutional. The federal government, the panel stressed, could not point to historical tradition similar. So I think that this is likely to get bounced on other grounds, because I believe there was a court order in place. Yeah, because there was a protective order in place. The protective order was in place. So I think this case is going to get bounced on other grounds. So I don't think the Supreme Court's going to decide the Second Amendment issue. What I think they're going to say is that he was subject to a protective order, and therefore he's in violation of the order. And if he thought the order was invalid, he has to challenge that in its ordinary course. You can't just violate a court order. You have to challenge the order in its ordinary course. A court order can be illegal, but you can't violate the illegal court order. You have to challenge it in its ordinary course. So I think the Supreme Court is going to say that the federal district court in the Fifth Circuit erred by striking down the statute when the issue is the order rather than the statute, right? Because it wasn't that he had a conviction and he was barred. It was he had an order and he was barred. So I think that's what's going to happen. And I think that's even more likely now after the whole thing in Maine, right? I don't think they're going to decide on the Second Amendment grounds. I just don't see that happening, but that's my view of the thing. In the Supreme Court, the Biden administration maintains the law is constitutional, even if it cannot provide an exact historical match for the law. It's enough, the Biden administration argues, that the law fits within a broader historical tradition of regulating guns, which that argument isn't going to work. Romney concedes the law could be constitutional if the federal government does not identify a historical twin, but the law is an outlier that our ancestors would never have accepted. So that's what they think, but I think they're unlikely to decide it. So that's what's going on. And the justices will finish off November with a complicated statutory question involving educational benefits for veterans relating to the Montgomery GI Bill and the post 9/11 GI Bill. Both bills provide up to 36 months of benefits for overlapping periods of time, prompting Congress to limit benefits under the programs. Veterans can only receive a total of 48 months of benefits and cannot receive benefits under both programs at the same time. The question before the court in the case is precisely how the two benefit programs interact. Ruth Isley was on active duty in the Army and the Army National Guard for a total of 8 years during the separate periods between January 2020 or January 2000 and August 2011. He first qualified under benefits of the Montgomery GI Bill, which he used for 25 months and 14 days to finance his undergraduate education. When Rudisley left the military in 2011, he applied to use the post 9/11 GI benefits to pay for his education at Yale Divinity School. The Department of Veterans said he was eligible for 10 months and 16 days of benefits, the same as his remaining eligibility under the Montgomery GI Bill, and the Court of Appeals for the Federal Circuit also agreed. In the Supreme Court, Rudisley contends that he's entitled to nearly 2 more years of benefits under the post 9/11 bill rather than the much shorter period offered by the VA. Under the text of both bills, he reasons veterans who qualify for benefits under each program with separate periods of service in the armed forces can use those benefits in whatever order they choose as long as they don't use them at the same time for up to 48 months. So it's just a very complicated statutory interpretation question. So not a lot to write about there. You guys want to know about the gummies? Is that what I'm hearing in chat? You guys want to know about the gummies? Is there a demand for gummy related stories in chat? You guys want to know about the gummies? All right. I'm here to help satisfy your requests. I'm here for you guys, the uncivilians. I want you to remember that. All right. All right. To the gummies. To the placenta gummies. Let's learn about Rob said he's going to bed. I'll believe it when I see it. I'll believe it when I see it. Let's learn about the placenta gummies. The moms eating placenta gummies and smoothies. Celebrities made this mainstream. Placenta encapsulation has become a mini industry in the United States. The moms are eating the placentas. Okay. Callie Landis makes a living dehydrating placentas for new moms to eat. As the founder of Lancaster Placenta Company, a lab in her Pennsylvania hometown, she takes the organs moms send her and turns them into capsules, tinctures, and bombs. She's most proud of the placenta gummy bears, saying they're pink and glittery, that encompass womanhood through and through. Okay. No one doubts that placentas help keep a fetus healthy. Yeah, that's kind of important. The organ, of course, attaches to the uterus, helping deliver nutrients via the umbilical cord. But even evangelists of placenta eating can easily rattle off a list of practices' supposed benefits for the mother after birth. They say it aids in breast milk production, reduction of postpartum depression, and helps with general postnatal healing. Okay. Celebrities like Alicia Silverstone, Chrissy Teigen, Mandy Moore, and more than one Kardashian swear by placentophagy, its official name. Last week, the reality TV star Caitlin Lowry posted photos of placenta smoothie made with help from the lab, a frosty strawberry-colored beverage that she blended in her kitchen and served through a mason jar. Okay. Apparently, the lesson here is you can get women to believe literally anything, I guess. I guess the lesson here is you can convince a woman of literally anything. Yeah. Traditionally, the practice is mostly used by midwives or doulas who present the postpartum snack in domestic settings. We're going to have to make a whole cookbook, people. You can imagine a new mother eating a placenta that's been cooked with spices and herbs like ginger or garlic a few hours after she's given home birth. But now companies like Lancaster Placenta Company have rebranded placentophagy as lab grade and mess free, giving birth to the mini industry of placenta encapsulation. Pictured here is a placenta gummy bear. I don't know what to say. I have no words. Nothing makes sense. The celebrities have really helped this go mainstream, Landis said. They took the image of away from those only being about crunchy, granola, natural remedy moms. Mommy Made Encapsulation, a rival company with locations in 5 states, is another such company. With celebrity clients that include Ashley Simpson, Shay Mitchell, Jenna Dewan, all the Vanderpump girls. Today we've done 300,000 encapsulations. Holy shit. Holy shit. 300,000? Women, what are you doing out there? Make it make sense. Please make it make sense. Corona, the founder, says these celebrities and influencers really propel my business. They allow moms to feel like they aren't the only crazy person who wanted to do it. They'll say, oh, so-and-so did this, and her baby didn't get sick. But at least in one case, a baby did get sick when her mother ingested an infected placenta. In 2017, the CDC warned against the practice after an Oregon baby was diagnosed with a strep infection. Her mother had eaten dry placenta capsules, and apparently this has somehow wound up hurting the baby. I don't know how. I don't want to know. The American College of Obstetricians and Gynecologists does not have specific guidelines on the practice, but a spokesperson for the association referred The Guardian to a 2017 study that found no scientific evidence of any clinical benefit among humans. and no placental nutrients or hormones are retained in sufficient amounts after placenta encapsulation to be potentially helpful to the mother postpartum. I mean, I guess. For now, the industry relies heavily on anecdotal evidence, which I take exception to that concept, but okay, as do most wellness trends backed by enthusiastic practitioners, but sketchy on science. It's so hard because there's not enough research out there to prove it one way or another. I am deeply dubious. I am deeply dubious that there's any particular health benefit to it. You know? If you told me it was especially rich in iron, I guess I'd believe you. But beyond that, well, also, what's with the cannibalism? Can we just clarify that this is technically cannibalism? And it's self-cannibalism at that. You're eating your own body. So apparently, there are a lot of women out there who are into the cannibalism. Women, you're crazy. You're crazy. The encapsulation services work as follows. Before birth, a mom will receive a placenta go kit that includes ice checks and packs, biohazard bags, and prepaid shipping boxes to send the placenta back in. On the day she gives birth, she tells nurses she wants to keep the placenta. Apparently, 4 states have laws that grant the mom the right to keep the organ. Of all the laws you didn't know that we had or needed, apparently 4 states have laws on the books. Yeah. This is yeah. When the frozen placenta is shipped back to the company, it's sterilized, the blood is removed, and it's placed in a dehydrating machine. The dry, cracker-like result is then crushed into a fine powder to be consumed in capsules. The capsules are flavorless and odorless unless you go for flavored options, like berry, bubblegum, grape, or lime. At Lancaster Placenta Company, the powder can be used to make smoothies or infused into tinctures and gummies. The mother can take the placenta edibles like a supplement until the supply runs out. Apparently, Placenta Care charges $375. Lancaster Placenta Company charges $299, and Mommy Maid charges $400 for the service. DIY methods apparently also abound on social media. Apparently, they've seen placenta cookies and placenta chocolates. I've even heard of placenta spaghetti. Yeah. Yeah, if Mrs. Uncivil wants to eat the placenta, I don't know, man. I don't know, man. And apparently Runkle has now joined Rob's chat. We will never truly end. Oh, there's more article. There's more article. I thought the article was over. I'm sorry. There's more article. I'm sorry. There's a whole more 3 paragraphs. Wang says that Placenta wants to align itself with other companies that turn biology into an at-home project, like 23andMe. We give them everything they need. It's an easy 3-step instruction, he says. A doctor might try to talk a mother out of keeping the placenta. It's stupid. There's no point. It's literally cannibalism. What are you doing? So Placenta also offers a text helpline, which Mommy Maid employs as an on-care coordinator trained to handle these situations. Just the other day, a mom who had a baby that was born a little small was told that the hospital had to test the placenta. Our coordinator got on the phone and told the nurse, "You're going to give her that placenta." No, I don't think I am. Doctor hesitancy aside, renewed attention on trends means encapsulator business is exploding. There are the hippie encapsulators. Wow. Okay. So they're calling out other versions of other companies as hippie. Guys, when you are encapsulating placenta for women to eat and you're calling out other companies as hippie, I don't know, man. I don't even know what to do at that point. But apparently, at least according to him, there are hippie encapsulators who say we put our blessing in every capsule. And then there are people like me, neutral and appealing to a lot of people. Apparently, they're not hippies. Also, what's up with this hippies? So that was the placenta gummy story. So I hope that fulfills your needs and wants. I hope that's everything you hoped and wanted for. Okay. Let's see what else we've got in the queue today. Oh, man. Let's do a Florida man story. I've now been streaming for an hour and 12 minutes. Where do you buy them with the uncivil discount? Yeah, no uncivil discount for you. I think we will not be offering. Yeah, could you imagine that? That's just yeah, that's a great marketing idea. So if I have a child, if I have a child, what I should do is I should turn that child's placenta into capsules, not for my wife, but I'll put it on my merch store, and then you can swallow the placenta of my child. A piece of uncivil. There's a unique merchandising opportunity. Florida man has been arrested for impersonating the police while wearing a Buccaneers jersey and flashing red and blue lights. Yeah. Odaiba from Twitch says, "Why wait for a human child? Go get deer placenta and make J merch." I can't argue with that. I can't argue with that. Thank you for joining us from Twitch. Tampa man was arrested on Sunday after allegedly attempting to pull vehicles over with his pickup truck that had been outfitted with red and blue flashing lights while wearing a Tampa Bay Buccaneers jersey. Probably not a real police officer. The driver is identified as 62-year-old Earl Mitchell Cicero, charged with false impersonation of a police officer. On Sunday morning, a Florida Highway Patrol trooper learned of a red GMC truck that was attempting to pull other vehicles over while flashing red and blue lights, according to authorities. At about 11 a.m., the trooper spotted and stopped the red pickup truck that was been operated by the man. Police spoke with the man who allegedly admitted to being in possession of red and blue lights that were on his dashboard before being pulled over, but the lights, he told troopers, were never activated. And I suppose this is a picture of the pickup truck? It must be. Wow. So I suppose this is an interesting guy, guys. Let's take a look at him. He's literally got the fuzzy dice. So that's pretty old school. He's got the fuzzy dice. He got also hanging from his rear view mirror what looks like perhaps a child-size baseball hat with what appears to be maybe possibly felt replica Beats headphones, maybe? Because it's got looks like it might have the Beats logo in there. I mean, I don't know if I'm seeing too much there, but that's kind of what it looks like on my screen, maybe. And then he's got these cheap-ass red and blue lights just parked right up on his dash. He's got a pink R Racing steering wheel wrap on his car. This is a choice. This is a choice for sure. During the investigation, I guess this is also partly the truck. Yeah, from another angle. Okay, and his GMC truck that he's got there. You know, the witnesses told troopers he believed the red truck may have been undercover law enforcement vehicle, describing how the driver of the truck motioned for him to pull over before speeding off. So apparently, he might have flashed the lights at somebody. So, yeah. When plugged into the electrical sockets, the lights did turn on. The trooper noted that both electrical sockets, which are used for cigarette lighters, already had their covers removed, and then was arrested and sent to jail. All that good stuff. Hey, you guys want to see a swoop? You guys want to see a new swoop done by one of my moderators who did a Thunderdome related swoop? You guys want to see a swoop? Let's do a swoop. Welcome to the Thunderdome, baby. Welcome to the Thunderdome. Thunderdome fish swoop, man. It's good stuff. It's good stuff. That one was done by Tony. Everyone say thanks to Tony. He's also done the thumbnails recently, many of them, and they've been fun. So appreciated as always. All right, let's see what else we've got. We got other stories here. All right, this one was just kind of stupid. Well, yeah. No, let's do something else. This is fun. Not a particularly notable story in a lot of ways, but just kind of fun. And it's okay just to have fun stories, right? They don't all have to be great. Virginia man. Virginia man was waiting in line for a chicken sandwich, got bored, bought a Powerball ticket, and won $1 million. So it worked out well for him. Best chicken sandwich of his life. Here is Carlos Gutierrez with $1 million. So that's nice. The Virginia man waiting for his chicken sandwich bought the Powerball ticket and won $1 million. Carlos Gutierrez of Centerville told Virginia lottery officials he stopped on his way to work to get a chicken sandwich and coffee from Lee's Sandwiches in Falls Church. While waiting for his order, Gutierrez spotted a lottery vending machine nearby and decided to buy a ticket for the evening's Powerball. He stopped at the store the next day and was told a ticket purchased from the machine and won $1 million, saying maybe it's me, and it was him. He only missed the Powerball number. He says at least that he initially was going to choose that number, but changed it at the last minute. And he says he plans to use the winnings to expand his small business. So good for him. Good for him. It's more like $500,000 probably by the time he's done with taxes and everything. But still, you know, a couple $100,000 of spare cash is nice. So, you know, not life-changing money or anything, but, you know, it should help him get his business a little bit further along. So that's nice. No one's going to turn down $500,000, right? So I guess you never know. I've bought in a couple tickets in my life. I haven't won anything. Yeah. My recommendation, by the way, if you ever win the lottery, yeah, here's my recommendation. The smart people will tell you the same thing, right? You never spend the money. What you do is you get yourself a Vanguard account and you put it in there and you either sink it all into the S&P 500 or you mirror, or probably what I do is I probably mirror the life cycle fund for current retirees that the TSP uses for the federal government, for the people that are currently like the no risk TSP portfolio, and just mirror that and just live off the interest. That's basically what you do. And the standard rule is you can take out 2% every year, basically forever, because the market will go up, the market will go down, and also you have to keep up for inflation. So the standard rule is 2%. So of course, also you're going to have to pay your taxes and fees and everything that's due to that. So you want to keep the money quasi-liquid so that you can pay off your taxes when they're due. And then you just let the TSP fund mirror the TSP fund and just let the interest do the work. It's by far and away the best advice. And keep your mouth shut as much as possible. Yeah. And keep your mouth shut as much as possible. If you can be anonymous, stay anonymous. Probably want to hire an accountant. But you really should not be spending any of the money. Just live off the interest and don't worry about anything else. Some states allow you to stay anonymous, some states don't. If you can, you should. And if you want my consulting services, I'll be happy to offer them for a nominal fee. All right, this one is interesting, just weird. Apparently, A thrift store in Wales is been forced to ask people to stop donating sex toys. This is apparently a problem. Don't donate sex toys to the thrift store. What? Yeah, so I'm gonna pop my tags, got $20 in my pocket. Yeah. The charity thrift store in Wales has been forced to ask supporters to stop donating used and unused sex toys. The store in Wales, which supports a children's charity, issued a statement asking donors to be careful what they bring in the store, saying, quote, "Could those of you who kindly donate please be mindful that we're a children's charity, and as such, we have a range of ages on our wonderful volunteer team. We therefore ask that you refrain from donating your used and unused marital aids. We'd like to remind you our branch has closed circuit television, so these items can be traced back to their owners. Thank you." I don't know what's going on, but that's what's happening, apparently. A representative for the charity store, the statement came after some recent inappropriate donations, saying, "We're always hugely appreciative of donations from the community, but it's fair to say there's some items are not quite the kind of toys that we were looking for," saying that they prefer children's toys because they're a children's charity. So apparently some people needed a lesson. I've been to many a thrift store. I can't say that I've ever seen a marital age at a thrift store. So either I'm going to the wrong thrift stores or they throw all that stuff away. I never thought about that as an option, but apparently some people saw that as an option, I guess. I don't know what to tell you. That is one of the things, that's what's going on. Let's see what else is happening on. Driverless taxi news. They're not really ready for prime time. Some companies are trying to put them out for prime time. They're not really ready for prime time, and amazingly enough, they're not all going well. Who could have seen that coming? Just literally anyone who knows anything. But they're trying. Cruise, which is a company owned by GM, trying to do a robo taxi service. It is not ready for prime time, people. It's really not. But they're trying. They have now suspended all driverless operations nationwide because it's not ready for prime time. Cruise, the autonomous vehicle unit owned by General Motors, is suspending driverless operations after regulators in California found the cars aren't, exactly ready yet. The California Department of Motor Vehicles this week revoked their licenses for Cruise, which recently began transporting passengers throughout San Francisco. It's a little early for this, man. It's a little early. We appreciate that you're trying to get this technology out. It's getting close, but it's not there yet. Cruise is also being investigated by U.S. regulators after receiving reports of potential risk to pedestrians and passengers. Cruise, for their part, says, "We've decided to proactively pause driverless operations across our fleet." It's not ready. It's not ready. The choice to suspend services isn't related to any new on-road incidents. Human supervised operations of Cruise autonomous vehicles will continue. There was a huge traffic jam in Austin caused by these autonomous cars. It was on the news, you might have saw. There was a huge traffic jam that was caused because the cars work if conditions are perfect, right? If everything goes the way they're supposed to, they work great. but they can't deal with disruptions, right? So you got cars in a jam and they can't negotiate how to get past the jam because they're all like waiting for each other, right? Because the situation isn't resolving, right? A human being, some human being is going to be aggressive and, take action, where human beings can negotiate, but the cars don't know how to do it, right? So the cars will work if everything is working, right? The cars work 99% of the time, maybe more than that. But, when you're driving as much as people drive, 99% isn't good enough. Yeah, 99% isn't good enough. General Motors has taken a hit this week. The Detroit automaker had been expecting $1 billion in revenue by 2025, a jump in $100 million revenue received last year. Cruise has also tested the service in Los Angeles as well as Phoenix and Austin. Maybe they were the ones causing all the problems in Austin. Maybe they're the ones causing all the problems in Austin. While the California Department of Motor Vehicles didn't elaborate on the reason for the suspension, the agency charged Cruise with misrepresenting safety information about the autonomous technology. Tuesday's revocation followed a series of incidents that highlight concerns about hazards and inconveniences caused by the activity. Earlier this month, a Cruise taxi ran over a pedestrian who had been hit by another vehicle driven by a human being. The pedestrian came pinned under the tire of the vehicle and then was pulled for about 20 feet as the car attempted to move off the road. Yeah. The DMV and others have accused Cruise of not initially sharing all video footage of the accident, but they say they did. I bet they didn't, though. In a Tuesday statement, Cruise said it's cooperating with regulators, and engineers are working on a way for robo-taxis to improve the response to this extremely rare event. See, the thing is that they're not extremely rare because it's a law of large numbers problem, right? It's a law of large numbers, right? The problem is that you have so many instances happen every day, right? There are so many cars driven so many times in the United States, right? 99.9999% isn't good enough. It's not. When you just think how many cars are driven every single day in the United States, right? In how many situations? There's a lot of cars. There's a lot of cars, right? 99.9999 is not good enough because of how many cars there are operating every single day, in how many different conditions every single day, and how many interactions every single day. How many times does a driver have to make a decision in a car? Right? Decisions you don't even know you're making, by the way, incidentally. It's not even things where your brain is necessarily on, because if you've been driving for a while, it's become basically automatic to you. But you're still making decisions because you're pattern recognition machines. But the problem is, they basically need to be perfect. They need to be perfect. It's amazing in some ways that we don't have more problems with vehicles than we do. They still kill 30,000 people every year, I think, give or take, but still, it's amazing they don't kill more people. Because just think how many cars are driving, how many places, how many times. Do I think no one should drive because humans make mistakes too? I think humans are more accurate than a car. I think humans are more accurate than that. The cars can't keep up. The humans are more than 99.9999% accurate. That's my point. The humans are better than that. And humans, I think, are better at dealing when things don't go right. Because human beings can problem solve and reason. I think they're better about fixing it when things don't go right. for the most part. Some people are dipshits. But right, if you have a situation that you've never seen before as a driver, you can figure out a solution. Usually. So, yeah, but the cars can't because they don't know what to do. Because they can't reason. So, yeah. The NHTSA's Office of Defects in Investigation said it received 2 reports involving investigations. You work at DOT, such a big push for autonomous vehicles, it was stupid. My advanced car is a pain in the butt. When it gets confused, yeah. It's not a bad idea. It's not a bad idea. And the technology is getting really good. It's getting really good. It's just not good enough yet. It's not good enough yet. It's not good enough for autonomous driving. Right? It's good enough to have a human being behind the scene, the car, who can take over at any time. But it's not good enough for truly autonomous. Not yet. In December of last year, the NHTS, but maybe soon. The technology is increasing pretty fast. So maybe soon, but not yet. According to an October 20th letter that was made public, since the beginning of the probe, NHTSA has received 5 other reports of Cruise AVs unexpectedly braking with no obstacles. Each case involved an AV operating without human supervision and resulted in a rear-end collision. Cruise has maintained that the record of driverless miles have outperformed comparable human drivers. I don't believe that for 1 second, to be honest. I'm sure there's some way of measuring where Cruise comes out on top. I'm sure you can creatively measure in a way that says, yeah, Cruise comes out on top. But not really, no. There could also be larger repercussions for the industry, with the month's news feeding into the emerging narrative that automatic vehicles and companies are struggling and failing. It's not ready yet. It's just not ready. Cities like San Francisco that are already concerned may see and use this as proof the industry is run amok. It is. It's run amok. Can't make an omelet without breaking some eggs? Yeah. Yeah, but you're supposed to fail before you go to consumer, right? You're not supposed to, especially with a product like a car, right? You're not supposed to deploy and fail and then be like, oh, I can patch it later, right? You don't, it's not a video game, where it's like, oh, we'll patch it later. I'll patch it after release. If we can't trust a company deploying automated vehicles, they have no business on our roads. Yeah, I tend to agree. For sure. For sure. I tend to agree. It's just not ready yet. Like Tesla's, automated driving with the user behind the wheel. As long as conditions are good and the lines are marked and they can see it tends to do a really good job, in normal conditions. It's just not ready for conditions when, things are not so great. Without a user behind the wheel, it's just not ready yet. All right. Let's see what else we got in the news. Let's see. Okay. This one is Florida Man. Good Florida Man story today. Thank you, by the way, to my moderators who helped with finding many of these stories, by the way. Their contributions to the channel are extensively appreciated, as always. Florida man tried to do an armed robbery to demand Viagra and other prescription drugs with a peculiar handwritten note. The 23-year-old alleged thief gave pharmacists special instructions on the note. So I guess he has no objection to doing hard time. Ha ha ha. Funny joke. Let's learn more. The 23-year-old Florida man is facing charges after police say he handed pharmacy employees a note demanding a laundry list of prescription drugs, including Viagra. The Orlando Police Department say that Thomas Muse handed a handwritten note to the pharmacist at CVS indicating that he had a firearm and would shoot them if he wasn't provided the drugs on the note. Pictured here is Thomas Muse, 23, who apparently is smiling and happy for some reason, I guess. He writes, "This is a armed robbery." He wrote in the note, "Please cooperate. I don't want to hurt you. You're not to alarm anybody, and I will shoot the closest person to me. Please follow the directions or I will shoot the closest person to me." Well, I mean, that's an interesting note, to be sure. I mean, this is an armed robbery. Please cooperate. I don't want to hurt you. You're not to alarm anyone or I will shoot the closest person to me. Please follow the directions or I will shoot the closest person to me. Bag the following: Oxycontin, 5 milligrams, 7.5 milligram, 10 milligram, 15 milligram, 20 milligram, 30 milligram, all bottles. Hydrocodone, 5 milligram, 7.5 milligram, 10 milligram, all bottles. Xanax, 2 milligram, 1 milligram, all bottles. Not sure why he wrote it in that order, but he did. Adderall, 20 milligram, 30 milligram, 75 milligram, all bottles. Liquid codeine / Pronith, all bottles. Viagra, 100 milligram, all bottles. When finished, place note in bag and I lay down, or I will shoot. I mean, it's okay. It's definitely, yeah. According to the news release, officers arrived at the scene as Muse was walking out of the store. Officers chased him on foot and eventually took him into custody. Unclear how the police were alerted, incidentally. I don't know if they have a silent alarm back there or whatever, but, okay. Police say he was still holding the stolen narcotics and his note at the time of the arrest. Okay. So, I yeah. That wasn't a threat. It was very much a threat. It was very much a threat, yes. Police also say, Muse, there's a silent alarm in nearly every pharmacy. Is there? It wouldn't occur to me that there'd be a silent alarm at a pharmacy. But okay. I mean, I guess it just wouldn't occur to me there'd be a silent alarm at a pharmacy. Police say Muse admitted to traveling to Orlando to Jacksonville to carry out the plan and confessed to another robbery in Central Florida. He is booked on robbery, trafficking, and possession charges. All those good stuff. Yeah, it wouldn't occur to me that there'd be a silent alarm at a pharmacy. I mean, it's not a bank, but okay. Pharmacies are big targets with all those drugs? I guess so. I guess it wouldn't have occurred to me. I guess me and him both. It just didn't occur to me there'd be a silent robbery at a pharmacy. But fortunately, I wasn't contemplating robbing a pharmacy because robbery is bad. Armed robbery is bad. So, yeah, I guess both he and me missed the memo on the silent alarm, but I got the memo about robbery being bad and not doing the robbery. So, it worked out okay for me. He's going to go to jail for like 7 years. You know? Yeah, but law school, not everyone can afford. If you need law school to tell you robbery is bad, I don't know what to tell you. See, this is one of those things, incidentally, like people will say sometimes. People will say things like, you know, like, how is it fair that you know, that I'm bound by the law when I don't know what the law is, right? It's like, because ignorance of the law is no excuse, right? And people sometimes say, well, how is it fair that I should be judged by the law when I don't know what the law is? And I always think to myself, bitch, you absolutely know what the law is. Okay? There are obviously okay. All the laws are common, either all the laws, almost all the laws with very few exceptions. Okay? Almost all the laws with very few exceptions are either one, dead shit common sense, or two, only would applicable if you have a reason to know. In which case, you would have a reason to know, right? It's like, do you really need law school to tell you that, like, stealing is wrong? Do you really need law school to tell you that hurting somebody is wrong? Do you really need law school to tell you, like, that, you know, threatening people is wrong? Right? I mean, you don't need laws for this. It's like, how am I supposed to know the law? It's like, most of the laws are pretty obvious and pretty self-explanatory, right? If you just don't do to other people what you don't want done to yourself, you'll be fine, right? That's a good rule. The silver rule. The silver rule. It's the golden rule in the negative. It's the silver rule. Don't do to others what you don't want done to you. Would you want someone to do it to you? If the answer is no, don't do it to someone else, because they probably don't like it either, because they're a human being, right? Bicycle regulations. All right. So yeah, there might be some ones where you'll get some fines, maybe. But it's literally called the silver rule, by the way. I didn't make that up. It's called the silver rule, if you've never heard that before. J Villa. It's just, that's what it's called. And I like the silver rule very much. It's a good rule to live by. Most of the rules are pretty obvious. You know, don't lie to people. Don't lie to people. Don't lie to people to get their stuff. That's fraud, right? Don't lie to gain advantage over somebody else and get their money. Don't steal. Don't hurt people. You know? Yeah. You thought it was something clever I came up with? It isn't. It's, it's, yeah. The silver rule. Yeah. I like it very much. So most of the laws are pretty obvious, I think. You know, it's like, if you don't need a lawyer to tell you that this is illegal. You know? Tax law seems like it'd be easy to break on accident. That's fair enough. Tax law is very complicated. That's fair. Although for most people's taxes are pretty simple. So taxes only become, for most people, taxes are pretty simple. You can do it on the back of a postcard. So, yeah. And incidentally, it's only criminal if you're trying to deliberately, purposefully not pay your tax. So if you're just making a mistake, which is fairly easy to do, you're just talking about some civil penalties. In other words, give us money. So it's only criminal if you're trying to do it on purpose. So again, like for criminal law, like knowingly, purposefully trying to not pay your tax, evade your tax, yeah. So most of the time, it's not too bad. Most of the time, it's not too bad. I'm arguing over implied consent. A roadside breathalyzer is required only arrest and at the station. I don't know the answer to that question. It's going to depend on your jurisdiction. I, honest to God, don't know the answer about whether the breathalyzer is considered the refusal or the one at the station is considered the refusal. I don't know. Other than criminal negligence, is intent required? Almost always, yes. Yeah. Strict liability crimes are very, very rare and tend to only apply. Statutory rape is one, although half the states aren't even that. So I think only in half the states is it strict liability. It might even be less than that. I have to double check. But in some states it's strict liability, but in other states it's not. We've still not covered SBF because I've been waiting for Rob for 2 hours now. But other than that, only strict liability crimes tend to deal with when you're dealing with dangerous things. So, do you have like dangerous animals and or dynamite and or a nuclear plant? Then, if you have those things, then, strict liability. But then again, they will tell you, right? They will tell you, or it should be obvious. You should know. So again, like strict liability crimes are not usually a surprise because you're dealing with inherently dangerous shit in which, you should be kind of careful because it's dangerous. So yeah. But yeah, that's one of the reasons mens rea is so important, right? The intent to break the law. I don't believe a raid's incoming. I think he lied. I think he's a lie. Let's cover the story of the python that's finally been caught 4 months after loose in Oklahoma. Danger Noodle over here. Was out and about in the wilds and causing all kinds of problems, and has been caught. Here is a picture of Danger Noodle having been successfully captured after 4 months on the lam. The 8-foot python was on the loose in Oklahoma City trailer park for 4 months. Snakes Alive Exotic Rescue and Sanctuary said the snake was located Wednesday in the Burntwood area, where it had been on the loose and sporadically sighted since June. Local residents had voiced suspicions about the python living off of neighborhood cats. But rescuers said the python showed no signs of having recently fed on pets or wild animals. I wonder how we're defining recently here, by the way. The snake, an albino golden child reticulated python, was apparently malnourished and suffering from a respiratory infection. So I guess everything wasn't going great for the snake. The snake will be taken to a snake hospital where the snake can, eat on small children or something. I don't know. So, Danger Noodle over here has been successfully captured and will be, will be made better. So that's exciting. All right, let's see as Rob continues to wrap up over here. We will cover Murdaugh, who has now officially filed his motion for a new trial. And I don't know how this will ultimately result in the end. I think there has to be a hearing on this issue. I don't know what the result of that hearing is going to be, but there has to be a hearing. I don't know how we don't have a hearing on this issue at this point, to be honest, when it comes to Murdaugh. There's just too many questions. We're going to have to get the jury. We're going to have to get the jury on the stand and ask them questions. I just don't know what else we can do here because there's just too many questions. And I don't know what the end result of that hearing will be, but I don't see how we get out of this without a hearing, to be honest. So Alex Murdaugh has officially filed his motion for a new trial. So he successfully got the Court of Appeals to put aside the appeal so that he can file his new motion. And we're going there. Alex Murdaugh on Friday filed his motion in Colton County for the new trial. His attorneys filed the motion asking the trial judge to hold an evidentiary hearing, which I don't see how you don't do, to be honest. I don't see how you don't hear the hearing. We've read portions of the book. Remember, we've been reading the book. Would you like to hear some of the book? It's been a while since we've read some of the book on stream. Some of the wonderful words of the Colton County clerk of court. Let's read some of the book. Let's see. All right. From the clerk of court. All right. We will read from chapter 18, entitled Curiosity in Colton County. Community connectedness is not just about warm, fuzzy tales of civic triumph. In measurable and well-documented ways, social capital makes an enormous difference in our lives. Social capital makes us smarter, healthier, safer, richer, and better able to govern a just and stable democracy. Robert Putnam. When the trial ended and the glare of the spotlight started to fade from the network interviews by the week of March 13th, our team at the clerk of court's office in Colton County thought we'd go back to normal with new cases. A funny thing happened, though. Just as people showed up all over the country during the 6-week trial, different people started showing up at the courthouse late in March, April, and beyond. They were the ones who were glued to the TV or internet during the trial. In mid-June, a Supreme Court justice from New York visited our courthouse. The Honorable Judge Kathy King was coming down for a close friend's wedding in Monk's Corner. And on the way, he's wrapping up. I can see he's wrapping up. Great. We're moving on. He's running the outro, guys. He's running the outro. We're about to get raided. I can see it happening. Anyways. Yeah. So the attorneys have filed a motion for a new trial asking for an evidentiary hearing as a result of the jury tampering from a result of Colton County Clerk of Court. When the facts are proven, the court must grant a new trial. I don't see how that doesn't happen, to be quite honest. The motion, which details allegations against Hill, were made last month by Murdaugh's team, bears receipt stamp from Hill herself in her capacity as the clerk of court. So she had to stamp the motion asking for the new hearing. That's so hilarious, to be honest. I just like the schadenfreude of it all, to be honest. The motion alleges that Hill tampered with the jury by advising them not to believe Murdaugh's testimony and other evidence presented to the defense. Did he seriously forget to raid me? Did he seriously forget to raid me? A request from CNN to Hill's attorney for comment was not immediately answered. CNN had also reached out to South Carolina Attorney General's office on Friday afternoon. Murdaugh's attorney declined to comment on the new trial motion. That sucks. Murdaugh's now notorious South Carolina fraudster and disbarred attorney is currently serving 2 concurrent life sentences. Dude. Hard to raid when you're subscriber only mode? No, it's not. Mama Bear, it's not hard at all. Hold on. Hold on. Ian wants a link. Hold on. No, I'm not okay. I'm really mad. I'm really mad. Okay. All right. Anyways, so that is the end of the Murdaugh case. So I will now move on to the Sam Bankman-Fried stuff. Hold on. Let's move on to Sam Bankman-Fried. We've been waiting to talk about Sam Bankman-Fried this entire time. And I'll cover it now. All right. Okay, anyways, let's go back to Sam Bankman-Fried. So we're going to pick up this yesterday. So Sam Bankman-Fried took the stand outside the presence of the jury yesterday and then took the stand in the presence of the jury today. So yesterday he took the stand initially for let's see, where is it pick up where he took the stand? Okay. So initially he takes the stand without the presence of the jury. Without the presence of the jury, because there's a question as to the scope of what he's going to be able to testify about. So this is basically, in practice, what this is a motion in limine with a proffer. So the motion in limine is to limit. That's what limine means. It's a motion to limit. And the judge is trying to decide what questions are proper and presumably what cross-examination is going to be proper. So there's some sort of motion that's apparently sitting out there in the ether that the judge has not yet ruled on. And so they're going to now call Sam Bankman-Fried, so he has to rule on the issue. And so the judge still hasn't made their mind up about the issue. So they want to hear testimony from Sam Bankman-Fried outside the presence of the jury, which is the proffer portion of it, right? Here's what he would testify to, right? So you can do this without the client on the stand, but in this case, I guess they're doing it with the client on the stand. How are you doing, Ian?
It's been an evening. Hey, Rob was trying to send people over. He had technical difficulties. It was not sending. So hopefully people
He forgot to set up the redirect.
He tried to set up the redirect. It just was not doing the redirect. YouTube is being crappy. So he tried to send people here. He's hoping, but
okay.
Yeah, I wanted to pop on. I hear you're talking about Sam Bankman-Fried and his.
Yeah, I was waiting this entire time to talk about it because I was trying to do the courtesy of waiting for everyone to finish Rob's stream so that they wouldn't miss anything.
Well, hopefully folks make it here because yeah.
Okay. So yeah, we were just picking up this yesterday. So basically what we're doing, as I was explaining, is we're doing a motion in limine with a proffer. So we're testifying about what we would testify to in the presence of the jury, but outside the presence of the jury, so the judge can hear it in order to determine what we can testify to. So we're doing a motion in limine on the fly. It seems like we're doing in practice. This is from yesterday, by the way, not today. So this is yesterday afternoon we're picking up. So they call Sam Bankman-Fried to the stand for the purpose of this motion in limine / proffer without the presence of the jury. And said, the AUSA asked, what's your practice on objections in a hearing like this? The judge saying, I haven't done this in a while, which I imagine you haven't, right? And you don't really need to do necessarily objections because the whole thing is necessarily to figure out what you would testify to. There's no jury, so you don't really need objections right now, but whatever.
They give you a lot more leeway on those, which...
yeah, right. Because it's a hearing, right? It's outside the presence of the jury. It's a little bit more informal.
Yeah. And sometimes sometimes lawyers use it to get away with all sorts of things, which might be fun with Sam Bankman-Fried.
Yeah. But the jury isn't there to hear it, so. But yeah, you can have all kinds of fun as you're just playing around a little bit. So they ask, what communication platform did FTX use? Telegraph, Slack, and Signal. What is Signal? It was not saved by any host. Was encryption important to FTX? Yes, we were hacked, so data would be vulnerable. Okay. SBF says we were headquartered in Hong Kong. There was some security concerns while we were there. Also, former employees might have had data to sell to a competitor. Did FTX get hacked? Never a core breach, but third parties were hacked. Okay. Pretty interesting. Tell me about document
Press does great work.
Yeah, Inner City Press. Yeah, because unfortunately, because it's federal court, of course, no television, no radio, so all we have is someone who's basically live blogging it. So we appreciate what's going on. KD says, don't lash out on Ian. I wasn't lashing out on Ian. I was just expressing my feelings.
And I was not taking it as I've had trouble with redirects this bit as well. I just wanted to come in and A, offer support, and B, kind of, say, hey, here's what's going on. Because I'm hoping people make it. So
yeah.
And
I love it I love it how chat sometimes is like, tell us about your feelings. Then I tell them about my feelings and they're like, Not like that. It's always a fun episode.
Oh,
But
I mean, that's kind of the nature of the game, right? Is people say, "Oh, we want to know how are you doing?" And you're like, "Well, here, like, I'll tell you." And they're like, "Yeah, no,
yeah,
don't do that." Like, that's
yeah,
if you ask, you get an answer.
yeah. I'm not gonna lie to you guys. I mean, for better or worse, I'm not very good about hiding my feelings. I'm hiding my feelings. I'm just like I'm upset. Um, anyways, pressing on. Also, Rob told me that he would be redirecting to me 2 hours ago. So
Yeah,
that's a little bit that's a little bit infuriating.
Rob and Time are they don't. I don't know that he's ever started a stream on time, and I also don't know that he's ever ended a stream on time. Um,
2 hours is a lot.
That's true. I've been doing my Monday streams, so I've been pushing them back while he's doing his Maya coverage to avoid like overlap. And I'm like, I need to push it back further because it always runs longer than all of that. So,
but that's enough inside baseball. Let's get back to the topic at hand. So let's see. Tell me about document retention. Our Dan Freeman worked on it and finds Feinwick and West where he used to work. What could participants do with the messages? For our informal chatter on Signal, they could be set to auto delete. The fact that they're doing this informal chatter thing, it's like, dude, what are you doing? These are business conversations. It's like this whole methodology is not keeping with exactly business practices, particularly with the amount of money that we're talking about. This isn't some small startup somewhere. This is a company that's handling billions and billions and billions of dollars. This is a little bit, yeah.
I would like some small portion of those billions of dollars. That would be nice.
Yeah. The judge says this could be helpful to me if it were more specific. Did you ask in accordance with policy? To my knowledge, yes. When you put on auto delete, those were not channels for our discussions. Uh-huh. Sure they weren't. Try to explain that to a jury. Oh yeah, they're not channels for decision. They're just channels for us to communicate things relating to the business between the upper leadership of the company. But it's not where we're making decisions. Uh-huh. What are you talking about? The weather?
I mean, this
I
is
don't
the
think
danger
so.
of having these channels is that sometimes people do talk about the weather. I
Yeah.
was talking to a civil lawyer who got he found out that there were a bunch of emails that weren't disclosed on
Yeah.
a secret internal listserv, and he thought
Yeah.
it was going to be great. He's like, this is going to be the best. The secret
Yeah.
internal listserv was that they had an online gaming thing that they didn't want all the employee, like it was just the inner circle, and like they were playing Halo with each other and stuff like that. So it was like, oh, I guess this isn't the smoking gun we thought it was going to be. So you never know.
You never do know, especially with as foolish as people are, man. But this is just not really. I'm not really being sold on a lot of this stuff, to be quite honest.
With this, it looks so greasy, right?
Yeah, it looks incredibly greasy, for sure. Let's put up an exhibit. Why'd you turn off auto delete? I heard from regulators. Who is Ryan Miller, General Counsel of FTX, and Brett Harrison, CEO of FTX? Okay. The judge says, one question, where is its policy? But let's move on. Tell me about North Dimension. Almeida set it up in 2020. How? Damn, Friedberg gave me papers to sign and I did.
Did he not understand the papers? Is that what he's trying to say?
I guess that's what he's trying to say. I suppose that's what's going on. It doesn't make any sense to me, but okay. Yeah, I'm trying to figure out why my donations are not popping up on screen right now. Another thing that I have to figure out. Why'd you sign for both FTX and Alameda? I was CEO of both at the time. FTX didn't have a bank account. Did you believe taking FTX deposits through Alameda was legal? I did. Great. So what is this? The application is Silvergate Bank for a North Dimension bank account. Who signed it? Dan Freeberg. Let's move to venture investments. Where the funds come from? Alameda Research. Doesn't the guy know anything about like don't commingle the funds?
Apparently not. I mean, I suspect that what he doesn't know could fill a lot.
Isn't that
So,
just sort of like business 101? Don't commingle the funds.
you'd think that's not really how he seems to operate, though.
Okay. Who would you do these issues with? Frederick and West, Dan Freeberg, Can Son. What was your understanding of the loan structure? You should have asked, what did you say and what did they say? So the judge apparently correcting them on the question. That's hilarious. But it's a hearing.
Yeah,
So the judge
no
can
jury.
be a little bit more fluid. SBF says, I told them of an investment I wanted to make. Sometimes instead of Alameda being the investor, I would be. I was thinking about it from a business perspective. Did you take comfort in how the lawyer structured it? Yes. Okay. Cohen, call up the terms of service. The judge, Mr. Bankman-Fried, did you read this entire document? Parts I skimmed. Dude, you didn't read your own terms of service? You're the running the company. You should probably know the terms of service of the company, I would think.
That's not how he rolls.
Apparently not. What did this apply to? I thought only futures trading. Alameda was authorized to do that. Who prepared the terms of service? Dan Freeberg and Fenwick and West. Let's move on to another topic, omnibus wallets. We put all our customers net Bitcoins, for example. You got into the crypto industry in 2017? Yes. The judge, Mr. Cohen, we need to know the basis of the witness's knowledge. How do you know that other exchanges use omnibus wallets? I tracked my trading on other exchanges. The larger exchanges use omnibus wallets? Yes. One more topic, the Bahama regulator, yes or no? Did you attend the meeting? Yes, with my father. Oh, father is directly involved there. That's interesting. That's a little bit of a tidbit there. Gary Wang was in the building, but not in the meeting. Yeah, throwing dad under the bus. Dad winds up wearing a jumper at some point. That'll be pretty hilarious. I'm here for it.
That gets embarrassing. It's like, oh, Dad, sorry, I sent you to jail for a long time potentially.
We all drove to FTX headquarters. The day prior there was a hack. They've been talking and moving assets. Cohen, let's move on. That night, did the Bahamian police visit you? Yes, I gave them my passport. One moment, Your Honor, nothing further. The judge asking to the AUSA, can we get a short break? Sure. During the break, apparently they're standing up talking with the lawyer, the U.S. Marshal standing up too. All the prosecutors have apparently left the courtroom to confer about what they should ask on the mock direct, or I suppose mock cross. Apparently that was the purpose of the break. Prosecutors are back and SBF is back on the witness stand, still no judge. The deputy says, I've been asked to remind everyone to avoid conversations while the hearing is going on. Cute. The assistant U.S. attorney, Mr. Bankman-Fried, I want to ask you about Signal. Did you discuss its use with your lawyers? Yes, in 2020. They were lawyers in Signal chat. Dan Freeberg was on the chat. An auto deletion? Yes. Again, the fact that these records are being auto deleted is not exactly encouraging. You know, the lack of trail, the lack of any sort of audit trail about how we're going on about something. Is there like, whatever. It's a problem.
I mean, don't you delete all of your no, you don't.
Well, also I'm not running a multi-billion-dollar company with, lots of customers' money and trading on the line. So do I do this is a little immaterial for whether I do this in this situation, because I'm not in this situation. I'm not anything like this situation. This is ridiculous.
This is kind of wild is what it is.
Yeah. When did you discuss auto deletion with them? I'm not sure what you're referring to. Shortly after I started using Signal. When did you start auto-deleting? 2021? That sounds plausible. At some point, I remember changing my toggle to 1 week auto-delete. Did you seek approval? No. When did the document retention policy go into effect? Mid-2021. Great. That's great. I don't know why we're running a multi-billion-dollar enterprise like the seat of our pants, some sort of tech startup, man. This is
I mean, to be
bizarre,
fair,
man.
they ran it straight into the ground. So,
Yeah.
well, ground. They ran it straight into like a volcano.
The
Yeah.
AUSA, did the policy deal with auto deletion on Signal? SBF, not on Signal specifically. The AUSA, what did it say you could delete company records? SBF, there was permissibility. The judge, meaning you could do whatever you wanted? SBF, the AUSA, where's the document retention policy? We look for it. The judge, you stick to the blockchain? SBF, the policy specifically addressed email, not other platforms. The AUSC, what lawyer did you discuss this with? Dan Friedberg. Dan over here sounds like a very accommodating guy.
Dan Friedberg right now is like, he's sitting there Googling non-extradition countries.
Yeah, this is interesting stuff for sure. AUSA, how was the retention policy decided on? SBF, my time period was not meant to be the policy company-wide for documents. AUSA, did the lawyer tell you could delete your messages with Carolyn Ellison, Gary Wang, and Nishad Singh? Not specifically. SBF, I apologize. I wish I had the policy now, my memory. The AUSA, do you consider Carolyn Ellison 7 spreadsheets a formal document? SBF's lawyer, objection beyond the scope of this hearing. Overruled. Yeah. No. The AUSA, do you believe that deleting messages with 7 different spreadsheets was permissible? SBF, yes. For example, verbal discussion was not required to be reported. AUSA, you were the CEO of FTX and she of Alameda? Yes. The AUSA, and you think deleting such messages were permissible? I don't have the policy in front of me right now. What about discussions of shutting down Alameda? I wouldn't characterize it that way. Wow. The AUSA, did you have discussions about a $13 billion hole? I don't recall such discussions. Do you think it could have been preserved? It depends. Adam Yida quoted you, preserving Signal would be all downside. I don't recall that. I was concerned the statements could be taken out of context, that it could be embarrassing. Did you share that with lawyers, not specifically in connection with the data retention policy? Did the lawyers tell you?
Like a circus,
dude. If he tries, I will get to his testimony the next day when he asked actually before the jury. But like, guys, this is not going to go over well. This is not going to go over well, right? You're trying to dance, you're trying to evade. Tap dancing in front of a jury usually doesn't end well. It's not good. Your credibility is quite a lot before a jury. This is not striking me with a great deal of confidence.
No, I mean, credibility's everything with a jury.
Yeah. Did lawyers tell you it would be all downside? I don't recall that. The judge. Did you believe it would be all downside, these signals? SBF. At my previous firm, Jane Street, we said anything might under on the front page. Okay. The AUSC. Did you tell employees to have certain discussions only in Signal? Not specifically. The AUSA. Did FTX get a subpoena not to destroy documents? Yes. Did you ask lawyers which signals you had to preserve? Yes. Ryan Miller and Dan Friedberg. Who decided what to retain? Ultimately, Dan and Ryan. Did you discuss the company business on Signal chats? Yes. What did they tell you? Preserve only formal business decisions. They used that phrase? I don't recall them using that phrase. So that isn't what they told you then. Now, is it?
Yeah.
Did anyone use the words informal business conversations and say that spreadsheets qualified? They were aware that sometimes would happen. You're having informal business conversations with spreadsheets? It's a very strange way of having informal conversations.
I mean, all of my informal hangouts have spreadsheets.
I know, it's just the new emoji.
It's like just drop in and hey Kurt, let's grab a beer and a spreadsheet.
Yeah. What spreadsheet you got for us today? I got this 21-year-old stuff. What
It's
about
got,
Alameda?
Pivot tables and
pivot tables. It's all about the pivot tables, yeah.
No, I still don't know how to do pivot tables. I got to learn that.
Yeah. What about Alameda? I believe they had a similar policy, was mentioned sometimes. When? Late 2021, after the CEO ship went to Carolyn Ellison and Sam. You don't actually have the document retention policy? No. Do you believe you ever violated it? I don't recall ever violating it. I like to take note that's not the same thing. North Dimension, why'd you incorporate it? Dan Freeberg. Dan is getting thrown under the bus. Yeah, Dan's the guy. He's the mastermind behind it all. Dan. Uh-huh. We're just pulling a Elizabeth Holmes over here. Yeah, it was all my advisors. They gave me the bad advice. Uh-huh. What was the relationship between you and Dan Freeberg? It changed over time. Can you zoom in? Okay, North Dimension. I don't recall giving him direction. Why was it called North Dimension? I don't recall. Okay. Why did FTX transition from a bank account with Alameda in its name to North Dimension? Did you think banks wanted to avoid crypto hedge funds? Something like that. So you were purposely misleading the banks? Sounds like a little light banking fraud to me. You know,
what's a little light
CEO of
banking fraud between friends?
Yeah. What is a little light banking fraud between friends? I mean, I help Ian with banking fraud usually 2-3 times a day, man. Just, it's just how friends communicate. Yeah. As CEO of Alameda, you don't know why it moved deposits to North Dimension? No. Did you discuss the bank account with Dan Friedberg? I'm not sure. I don't recall. You weren't involved in deciding on North Dimension? Not in particular. I may have been in conversations. Sure. I don't believe you, sir. I don't believe a word you say. This jury of one. I do not believe you, sir.
That's okay.
So you don't remember specifically, is that it? I want to make sure I'm answering the right question. Oh, I'm sure that's it. Yeah, you just want to make sure you're answering the right question. The permissibility of using North Dimension to take funds, only if you count Alameda. The judge, listen and answer directly.
Ooh. Judge thinks he's a weasel.
The AUSA, let's take a look at a different document, the banking application document you signed. You were CEO of Alameda? Yes. That's a wet signature? Yes. Meaning he actually physically signed it. Did you review it? Huh?
Pen and ink.
Right. Did you review it? Briefly. A lawyer presented to me, but no discussion. Let's go to page 1. Description of the business. Trading firm. Was North Dimension that? It was part of Alameda. Did North Dimension act as a trading firm? Not that I'm aware of. Did you review witness notes on Dan Freeberg? Not at all. Are there any other lawyers you talked to about North Dimension being able to accept funds? I'm not entirely sure. Were there conversations with auditors about the funds going to Alameda and North Dimension? Not that I recall. Presumably that's what it's supposed to say. SBF, I should say I'm not a lawyer. I'm just trying to answer based on my recollection. At the time, FTX, certain customers thought accounts would be sent to Alameda. FTX would keep a debt, repayable. I did not create this payment agent agreement. As far as you know, this was the agreement. Was the agreement ever disclosed to the public? I'm not aware of that. Okay, and then we move on to the terms of service. What is this provision about? Assets posted as collateral for the positions. Did you have discussions with Can's son about Alameda's exemption from automatic liquidation? No, I not by name. I was not aware of these topics by name. So you called them other things? You used euphemisms around the office? Is that what you did? What do you mean by that? I don't believe I was aware at the time. Sorry. I'm aware of the lines of credit. You said speed bumps. What do you mean? I apologize. This will be a somewhat substantial digression. I'm asking about Alameda's exemption from auto liquidation and speed bumps. What do you mean? Some combination of delays and alerts. I apologize. I wish I could give you a more specific answer. Do you? Do you wish that? Do you wish you could give a more specific answer?
They do not.
I'm asking about a typical customer. And let's see, maybe there's some more. Is there any more of this? Okay. If you mean not a market maker, were you aware that Alameda could be an overall negative balance? Adding up all assets, is that correct? Yes. Now please answer. I'm not sure it was in the code base. SBF, I may be understanding what the allow negative feature was. Do you mean negative asset value? Let's pull up the exhibit. SBF's lawyer. I object to this. This is a deposition now. I mean, a little bit, yeah. But that's what they want to ask about. We're doing a deposition. Yeah, it kind of is like a deposition. We're doing a deposition live in court with the judge as a proffer, as a motion in limine, as whatever the hell this thing is, in some sort of hybrid. But that's okay. We can play this way. The judge. I'm going beyond my tether here. Part of the problem is that the witness has an interesting way of responding to questions. Cohen, part of the problem is this type of hearing. That's the wrong thing to say. The judge, if you want to put this defense on, it's through this hearing or not at all. So the judge is trying to decide what defenses they can offer. That's great. So he's trying to determine whether what they're trying to offer is a legally cognizable defense. That's how well it's going for the defense. I may not even let you offer this defense to the jury. That going just that well.
He going to
I understand.
Jail.
Yeah.
He going to jail.
The question
forever.
The question never mentioned net asset value, but you keep using it in your answers. I apologize. I'm going to move on. When did you believe Alameda was permitted to borrow funds from FTX? I believe it was permissible to borrow from assets held as collateral for margin positions. Did that include anything? That include withdrawing assets off the exchange with risk analysis? What attorneys did you discuss this with? I discussed it with Ramik about 3 Arrows Capital. Ramik Aurora is not an attorney, so no attorneys? The answer is no. Let's talk about loans. Were they all documented? I thought so. Did you discuss with lawyers that the funds were coming from FTX customer funds? I would not characterize it that way. So no, I didn't discuss that with the lawyers. Why not just do it through Alameda? The investment target didn't want Alameda. For example, with Robinhood, you didn't want Alameda to be the investor? Right. It could be a conflict of interest. Well, since when do you care about conflicts of interest, man? You're in the most tied up, batshit crazy monetary scheme that I've ever heard of in my life. No wonder it was taking them so long to unravel all this.
Oh man. This guy
was the buyout. Go ahead.
This guy's going to jail.
No, he's definitely going to jail. He's going to jail for a long time.
Not long enough.
Was the buyout?
I don't think he's got enough lifespan left for long enough.
Maybe he can be cellmates with Bernie Madoff, and they can talk all about their various schemes together and how they were done wrong.
They should get him a cell with what's his name, Daryl Brooks.
Yeah,
just so he can yell grounds at him the whole time. I figure that's what he deserves. Grounds.
This is the best part here. AUSA, did you believe you should not embezzle customer assets? Objection. Sustained. No, I did not believe I should do that. You don't have to answer after sustained. Haven't you been here for 4 weeks? I felt I had to answer it.
Haven't you been here for 4 weeks? Oh my god, that is the best.
Chastised by his own attorney. Chastised by his own attorney in open court. That's good shit.
You know that his lawyer is going like, this freaking clown had billions of dollars on hand and yet can't figure out, like, somebody was asking me, like, didn't they prep this guy? And I was going, I'm sure they tried. I just don't think SBF is the learning type.
Yeah, no, for sure. No, it's just going just that well. That was the one that Rob highlighted for particular attention when he talked to me about this story. So I thought that was pretty good.
Yeah, it's nuts.
The AUSC. What about CEOs of exchanges using customer funds for personal expenses? Objection. Sustained as to form. Oh, you didn't answer that one? Okay. You had conversations you led you to believe was correct. We spoke about margin calls. Let's talk about Dan Freeberg. You hired him? Yes. You were reluctant in hiring a general counsel? I was reluctant to hire the wrong general counsel. Objection. It is relevant if he didn't want to hire a respectable lawyer. The judge, I'll allow it without necessarily endorsing the word respectable.
I love that. That wasn't intended as shade, but it comes off as shade.
The AUSC. Were you aware that Dan Freeberg was general counsel at a firm that had an inside trading scandal? Yes, a high-level scandal. A criminal scandal? Objection. I'll allow it. I bet you will. The AUSC. Were you aware that Dan Freeberg used illegal narcotics? Objection. Sustained. Mr. Sassoon, may I have a moment? No further questions. You're excused. Fun and exciting. All right, so then we'll read some comments from the judge.
That's the sort of thing you'd ideally like to get in front of a jury.
Oh yeah, no, I'm sure that they're going to get this in form. They'll get this in the spirit before the jury. I'm quite sure, because Sam Bankman-Fried can't help being but Sam Bankman-Fried. There's no way that this doesn't manifest itself in one way or another to the jury. So I'm quite confident that when we get to today's testimony, that we'll see some more. But as the judge is hearing the motion on this proffer motion in limine, can I offer the defense, whatever this thing is, the judge says, I'll hear from counsel on the issues I have to decide. Cohen, we think we can elicit testimony we've gone today. We're not advancing the formal advice of counsel defense, only that he reasonably relied. Okay. The judge, let's assume someone robs a bank, knocks over a Walmart, whatever, and they get a chunk of money. Do we agree that engaging in transaction to conceal the source of the money is money laundering? Sure. Now he gets legal advice about how to buy a condo with the money. The defendant is charged with money laundering. The defense is, I had a lawyer. I didn't have criminal intent. How's that different from what you're trying to do in principle?
Oh, this is bad questions to be getting from the judge, because this tells you that the judge is like, I understand your argument.
Yeah.
It is bullshit. And tell me why it's not bullshit.
So what he wants to try to do is so now I understand what's going on. Now what they're trying to do is he's trying to say he didn't have criminal intent because he had been informed by his lawyers that everything he was doing was legal. So therefore he didn't have knowledge or intent of illegality because he relied on the legal advice of other people, which goes to his mental state, right? So it's not exactly an excuse because he didn't know the law, but it's like, I didn't know that I was doing something wrong because I was trying to follow their advice. So that's what they're trying to do. And the judge is like, wait a second, right? Like, yeah, if you knocked over a Walmart and got the money and, then his lawyer told him to buy a condo with the money, he couldn't rely on this. So how's this different? So that wouldn't work in that situation. So how does it work in this situation? SBF's attorney says robbing a bank is illegal. Our position is that the source of fund was not illegal. The judge, but you need to tell the lawyer what the facts are. Cohen, there were times like the founder's loan. I'm dubious, but I understand your position.
I understand your position is one of the worst things you can hear from a judge, because it basically means I don't agree with you, but I also want you to stop talking. Like, you're not going to win, but also stop trying.
The AUSA, this is a collateral involvement of a lawyer, which doesn't go to the key question, the use of funds. There's no testimony that Dan Freeberg was told about the agent agreement. The judge, can Sun say there was omnibus wallets? I'll put that to one side. I'm planning a ruling tomorrow morning. We're planning cross-examination. Why am I not surprised? If the witness is not responsive, it'll take longer. I bet it will. Our subpoena to Feinbeck and West was denied. A trial subpoena? No. Okay, thanks. Adjourned. So that was from yesterday, which brings us to today, where the jury, bring in the jury, as we say, bring in the jury, and we will hear from all of that for sure. All right, so let's see what happened today. Okay. The judge, anything before we start? The AUSA, there were noises from the gallery yesterday. The judge, if people continue, they'll be removed. The AUSA, and I ran into a juror on the way in. I'd like an instruction that we're not being polite.
That we're not,
because obviously they didn't talk to the juror.
Right? Oh, right.
Of course they didn't. Yeah. The judge, will do. Mr. Cohen, SBF's lawyer Cohen, we oppose anything said yesterday on cross being used today. The judge, there is danger that the defendant using advice by lawyers in the past as an attempt. Strike that can suggest legality. The judge, the problem is it's misleading impression. It's one thing for a defendant to come in and say, I had a plan, and told the lawyer everything. A lawyer told me it was legal, so I had no criminal intent, but that's not what happened here. The judge, I had to know exactly what happened. The U.S. moved to preclude, but I declined to rule. Facts were at too high a level. Now we've had the hearing and I've heard the facts from Mr. Bankman-Fried's mouth. Cross was necessary. I have a slightly better sense now. The judge, all this was done so the defendant had a full chance to make his case, to show that it would be appropriate. He's had his shot. Now I heard yesterday that Mr. Friedberg and others implemented data protection, no surprise. I don't see the harm to the public interest to allow the defendant to adduce evidence the counsel was involved in producing the data protection policy. The U.S. can ask how we knew, so to that extent, I'm granting defense application. The other 4 instances, the lawyers drafted plain vanilla legal opinions. We're not going to allow that. In the event there's conviction, I'll write it on the subject, no doubt, longer than anyone will like. So only the one thing is in. So all these other advice from counsel, it gets excluded because it's immaterial to the question. Burn. Burn. Your defense is denied, sir. You can't argue the defense. So the lawyer helped to draft the data retention agreement, so you can ask about that. But these other 4 things that counsel did, you can't bring it in. You can't argue the defense. Defense denied.
And that's brutal, because that would have been critical for what they were trying to do here.
Yeah.
Like, because all through this, they've been trying to kind of muddy the waters.
Yeah.
And the judge is just shutting it down left and right, and they're not,
which I appreciate.
Wins
I personally appreciate that, because we've seen too many judges who are like, I'll just let it all in through the jury, and they don't do their gatekeeping role. And this judge is like, okay, first of all, this is my courtroom. We're moving along. This case is moving. So first of all, we're moving along, and second of all, I'm actually going to make decisions. And you can't do this. I gave him a chance. We had a hearing. I gave him a chance. You can't argue this. You can't, because you didn't give the lawyer all the information. Yeah. So you can't then say, well, I relied on the lawyer's advice, because the advice was based on bad information. So the lawyer's advice was no good, but that's your fault. That was your fault. You could have given them good information. At which point the lawyer presumably would have given you better information.
Yeah,
a better
specifically
opinion.
They would have given you better information, like that thing you want to do. Don't do it.
Yeah. So
that would be a bad idea.
Therefore, this is all your fault. And so you can't hide behind the shield of the attorney's opinion, because it's worthless, because you made it worthless. So you can't bring it into the defense. So all that gets excluded. It's out.
Meanwhile, the lawyer's like, thank God.
Yeah, thank God, right?
He's like lighting a candle at his church right now.
Yeah, no doubt for sure. So just to illustrate, the fact that the lawyer was involved in drafting a promissory note from a loan that Bankman-Fried took out from Alameda has no relevance to the case. So it doesn't matter that the lawyer drafted it because who cares? Right. It's, we had an open issue about omnibus wallets. Have you worked it out? Cohen, if we could confer with counsel at the morning break, I think there's a lack of clarity. Omnibus wallets on the blockchain with respect to crypto, I don't understand that that has to do with fiat. Cohen, on the use of what was said yesterday, we'd like to have a standing objection. There's no provision for that in the federal rules. Nice. Make your record as you will. That's the rule. Let's get the defendant on the stand and situated. Burn. Can we have a standing objection? No. You can object. You can object as you will, but there's no provision for it in standing rules. No, you cannot have a standing objection. I like this judge. I like this judge very much. This judge is in control of their courtroom, and I'm here for it.
And I mean, the next thing we're going to hear is they're like, can we have Chinese for lunch? And the judge is like, no, we are having pizza. They're just not getting anything.
Yeah. All right. Okay. So then the judge says, Mr. Cohen, who's your witness? The AOC says, Your Honor, the instruction. The judge says, if you encounter a lawyer and they ignore you, they're not being rude. Because of the whole passing the jury in the hall thing. Anyways, next witness. The defense calls Mr. Bankman-Fried. Here we go, people. Before the jury gets to hear this part.
Oh God.
What did FTX stand for? You mean like morally? The futures exchange. We thought we could build the best product on the market. Did it work out that way? No. FTX declared bankruptcy. A lot of people get hurt. Did you defraud anyone? No. How did FTX work? It was primarily
the
a
jury
margin
already
exchange.
doesn't believe him, but at this point,
Yeah. It was primarily a margin exchange. It works out like a mortgage. Objection narrative sustained. So yeah, narrative as the sort of implies is you can't ask a question that for lack of a better description calls for a really long rambling answer. So how did FTX work basically is not a precise enough question. So objection narrative is like you're basically asking him to give a speech and you can't do that. The questions have to be break it up into parts, break it up into their component parts, and then what happened? And then what happened? You can do that. You just can't call for them to just, go on a long rambling diatribe. Cohen said, with whom did you live in college? Gary Wang, Adam Yida, and others. Then where did you work? Jane Street. It was not a high frequency trading shop. Did they tell you not to engage in front running? Yes. Which desk did you work on? What is a desk? I mean, we all know what a desk is. Forced laughter. SBF. A desk is about 20 traders. I was in international ETFs. Did you like working at Jane Street? Yes, they treated me well. Did anyone else come with you to Alameda? Yes, Carolyn Ellison, Adam Yedida, and others. Why did you start Alameda? Crypto was getting public in 2017. I'd see two people talking silently. It was probably about crypto. There was demand. Dude, if you see two people talking and it's probably about crypto, I suggest you're hanging out in the wrong places.
I mean, to be fair, like a lot of places, if you see two people talking excitedly, it's probably about meth. So that said, I feel like the meth is probably the legally safer thing to be investing in right now.
Meth does have a secure it's a secure product with a well-defined and very eager market.
For the chat, this is not legal advice. This is us being snarky. Do not invest in meth. It probably doesn't end well.
No. I haven't invested in meth since I played Drug Wars 2002. Did you ever play that on your calculator?
Yep.
All right.
Great game.
Yes. Crypto seemed like the place with a big demand for arbitrage provider. What did you know about crypto? Basically nothing. Great. What did you borrow from Alameda? Genesis, Celsius, BlockFi, Voyager. I believe those are different computer programs. Where was Alameda's first office? An Airbnb in North Berkeley, California, with a lot of Amazon boxes in it we had to deal with. Why is it called Alameda? Berkeley's in Alameda County. We wanted to be under the radar. I didn't want to call it.
Is not a great thing to say in front of a jury. Like, we wanted to be under the radar. I mean, just say we didn't want to call it Fraud Incorporated.
I didn't want to call it Sam's crypto trading firm. Our internal name was Wireless Mouse. Who else was in the Airbnb? Myself, Gary Wong. Why'd you invite Gary Wong? I trusted him. He was a brilliant developer. How were you compensated? I had a $200,000 a year salary. Then we hired Carolyn Ellison. How'd you know Nishad Singh? He was a good friend of my brother's. I didn't know him well. He was working at Facebook. Sometimes there were sharp divides. Did there come a time when you spoke with Miss Ellison about what happened? Objection. The judge. Bankman-Fried, you can only answer with what you've said. I apologize that I not told her about the problems. We were making 50 to 100% profit annualized. That's a lot.
Yeah.
Then where? We moved to Hong Kong. I went to a conference there. I had many useful meetings there. I rented a WeWork there. Gary then Nishad came there. We started FTX. Have you heard of clawbacks? Yes, the value went negative. We could reach out to the user, but we couldn't rely on that for most users. If FTX couldn't cover it, it'd be a socialized loss to other users. Did you write explainers? Yes, we published them on our Zendesk. Let's call up the exhibit. This is not evidence. The judge. No harm, no foul. The judge is definitely not liking Mr. SBF very much, I think. Did you recognize this document? Yes. Explainer on spot margin trading. Did you set forth your views on the industry? Yes, in blog posts. Let's call one up. Objection. And then there's apparently some sort of sidebar. We'll be taking our morning break and the jury exits. All right. Then apparently they come back. Or no, there's no jury at this point. The judge says, Mr. Cohen, for what purpose is this being offered? That FTX said it would avoid clawbacks. Not that it did it. We found an exchange with the trader involving Mr. Wong. The Wong document. I think the government is going to try to argue at closing. The U.S. will argue that FTX was a fraud from the beginning. The judge. I don't know what the U.S. is going to argue at the end of this case any more than you do. Let's get the jury. Cute. It's like, I don't know what they're going to argue. It's like, and what they do argue is their business, and you can object then, if you have a problem. The jury enters.
Oh, they're going to have a problem.
Why'd you like Hong Kong? Better regulatory environment. Also, no extradition because it's China. How did you get customers? We asked our friends. We made improvements, word of mouth. It spread organically through social media. We interacted there. What about support tickets? I tried to answer some of them, well, a handful. Once FTX was up and running, did it have any relations with Alameda? Yes, Alameda was a market maker. And the risk windfall? If the account went negative, we'd start selling off. But if late, we had backstop liquidity. Okay. We increased the number of servers for the risk engine, but we learned that if there was erroneous liquidation of Alameda or any other large account, the AUSA, objection. Finish your answer. It would be catastrophic for FTX. So I told Gary we had to stop such liquidations of Alameda's accounts. They told me it done it. Now I know it was the allow negative. Tell me about the line of credit of Alameda. It grew over time to billions. I want $1 billion of credit. Ian, can I have $1 billion of credit, please?
No. For the simple reason that I don't actually have $1 billion to extend you.
I'll be your friend.
I would if I could. I
appreciate it.
I got no billions. Like, not even one. It's kind of sad.
Yeah.
I got 0 billions.
Millions?
I got 0 of those. I got tens. I could loan you a 10.
Can you loan me $10?
I could do that.
All right, great. Make it. Did there come a time when you had a discussion with Gary to shout about Alameda? Objection leading. Sustained. Did you have a discussion and with whom? Gary and Nashad. We increased the line of credit. At the time, I wasn't entirely sure what happened. I thought the fund was being held in a bank account or sent to FTX as stablecoins. If Alameda was keeping it, I figured it would be reflected as a negative number on FTX. What pages would you have opened in 2022? Signal and spreadsheets, a few websites. In some of Alameda's pointer pages, they were on my auto open. Did FTX have terms of service, and are these them? Yes. Tell me about FTT. It was FTX's token. What is buy and burn? FTX each week would use 1/3 of its profits to buy up FTT and burn it. Did FTT trade on the FTX exchange? Yes, and other exchanges like Binance. Did there come a time when Binance moved to sell off of FTT? Yes, we had a meeting with Sam Trebico and Carolyn Ellison. What is market manipulation? At Jane Street, they said bad trades to change the price of an asset. Objection. The lawyer, I can follow up. The judge, you can follow up when I'm done. Jurors, you'll take what I say manipulation means as the law of this case.
Oh, nice.
Cohen, yes or no? This definition came from Jane Street. Well, judge, yes or no? Judge is not having it, man.
Judge does not like him at all.
Having it, man. Yes.
The judge is like, I have no patience for your bullshit, and you are a bullshit artist. We are not doing this. I like this judge.
I like this judge. They're in control. And it's like, I'm ruling people. This is my little kingdom over here. And we're going to do this my way. And this is your reality now. So, let's all get on board the train. I appreciate that. Who was Sam Trebenko, co-CEO of Alameda? What does that even mean, co-CEO? What does that mean?
I guess they're both CEOs. I guess it means it probably means they're going to share a cell.
What kind of hours were you working? On a light day, 12 hours. On a hard day, 22 hours. You were working 22 hours in a day? I don't think so. I took a day off every few months. I had like 60,000 unread messages.
I can tell you I'm going to be doing a 24-hour live stream. That'll be a 24-hour day. That's for charity. I don't think that's what FTX was doing. I can tell you I'm not doing 2 of those in a row.
Yeah. How many signal channels were you on? A few hundred, I think. Did the growth of FTX impact your relationship with Alameda? I had to stop being CEO, but I was still interested in the ventures. I turned it over to Carolyn Ellison and Sam Trebeco. They were capable people, a good team. They were the best I had. It says a lot about so many things. That Carolyn Ellison was the best you had. Carolyn was a good manager, emphatic. Empathetic?
Yeah.
Empathetic, thank you. She was not a software developer. She was good at doing research. She had not focused on risk management. Did Trabuco step away? Yes. Toward what would effectively be early retirement. Good for him. I suggested a new co-CEO, but Carolyn said no. Your Honor, this might be a good time to take a break. No. Or rather, okay, be back at 1:30.
Oh, wow. When the judge is like so used to just saying no to you that they're like, no, no lunch. Yeah. Oh, wait, lunch is a reasonable request. Sorry. You caught me by surprise asking me something reasonable. I wasn't expecting that from you guys. It's like, oh, this is a bad place to live.
The judge, Mr. Cohen, when will your direct be done? The Cohen, Monday. When on Monday? Monday morning. Okay, get the jury. The judge is not having it. The judge is like, okay, let's move this train along. When are you going to be done? Monday. When? Mark it, book it, baby. This train is moving. Man, the judge really wants to get this case to the jury. They'll get it by Wednesday. They'll convict him before Friday. It's all going to hell.
It's like, I
Why
want
did you
your client in jail before lunch.
no joke. Why did you leave Hong Kong? Again, regulation didn't move forward. Also, domestic issues, COVID quarantines. We could do job interviews. Also, domestic disputes with China. Where'd you go? The Bahamas. They had regulation we found sustainable. Thank you for the super chat, Sarah, by the way. Appreciate that. Spending the last week from Las Vegas, now stepping in. Thank you for covering and making this a perfect Friday. Thank you very much. And thank you also earlier for the people earlier who donated earlier in the stream. I didn't acknowledge you as they came in. I was trying to figure out why it wasn't popping up on screen automatically. And I was so busy trying to figure that out, I neglected to honor you as they came in. And I apologize. Because it's supposed to pop up on screen and it's not popping up on screen. And it's making me sad.
That is
pressing on. Okay. Let's see. How many people did you live with? We moved in an apartment for 10 of us. Who was there? Carol and Nelson, Adam and Andrea, Gary and Cheryl, Nishad and Claire, Ross and Leah. Here you are with a deck of cards. Why? I use them like fidget spinners. Did you ever go to Las Vegas? Objection. When did you break up with Carolyn? Spring of 2022. She wanted more than I could give. It wasn't the first time with me. It'll be the last time with you. Yes. Let's look at the document from Caroline. Objection sustained.
I don't think he's getting conjugals.
No. Yeah. When were you the CEO? Did you prepare balance sheets? Yes, using Alameda pointer system. Objection, basis. He could have asked the witness who prepared the spreadsheets. No speaking objections. Okay, I guess that's fair enough, I suppose. The judge, counsel, we're all trying to get to the bottom of things. If I solicit the basis of the objection, it's for that. If you prefer no reason on appeal, let me know. We'll go forward as you prefer, Your Honor. Burn. Burn. Right? It's like, if I want a basis, I want a basis. Do you not want a basis on the record for appeal? Well, we'll do it your way, Your Honor. That's right. Judges, particularly federal judges, are demigods. I've said this before, and this judge definitely is emblematic of that. Judges are demigods. And
the last thing you want is when the judge is telling you, hey, when you appeal this, because they're like, we weren't hoping to appeal this. We were hoping to win today.
Yeah. And this judge has been elevated to the priesthood and the on high, and they're aware of it, and you will obey their will. And yeah. Cohen, let's talk about marketing. What was your approach? I know background, like you had background in anything else. But as we grew, I thought about it. I was suspect of Facebook and Google ads. I thought brand marketing would be better. Miami-Dade Arena, how'd that come about? Names of stadiums in America that are widely known. I, as an average level sports fan, could name them, even if I'd never been. I would watch Dak Prescott and sleep number bed. No one remember it. There were 4 available. Miami, the Kansas City Chiefs, and the New Orleans Saints. There were discussions. As to the Kansas City Royals, I didn't want FTX to be known as the Kansas City Royals of crypto exchanges.
Ouch. To be fair, though, the Kansas City Royals doesn't want to be known as the FTX of sports teams.
Yeah.
So I feel like they're in agreement on that one.
Cohen, you mentioned venture investing, early stage projects. Explain. Not yet mature, something like a startup. Did you do due diligence? Yes. Who believes that? Who believes that SBF did due diligence? I don't believe that for 1 minute.
Does due diligence involve like drinking a scotch and then calling it a day?
Yeah. I don't see that. SBF, me, Ramik, and Amy. Did you do due diligence on Solana? Yes, I came away from my calls. Objection, hearsay. Don't say what anyone else said. I end up thinking, objection. I invested in Solana. This list of properties, did FTX purchase them? Yes. We wanted the core staff to move there and to recruit others. Who was the public face of FTX? I was. My interviews went better than I thought they would. The demand grew. Why'd you wear shorts and t-shirts? I found them comfortable. Why the long hair? I was lazy. Well, that's definitely what you want to hear from the guy who's responsible for managing billions upon billions upon billions of dollars.
I mean,
billions upon billions and billions.
I get it.
Billions
I get
upon.
the long
Thank you,
hair.
Laura Lini, for the gift memberships. I appreciate those. Those are very kind. I appreciate that. Thank you very much. 10 gift memberships. Thank you very much for those gift memberships. Who was in the photo? Katy Perry, Michael Knives, Katie Hudson, and me. We were running a Super Bowl ad. When have you met Michael Knives? I was at Knives or Kives, and I've been one in the state. I ran into them, and they invited me in. Did you invest in Kives K5? Yes, I thought we were promising incubations and celebrity contacts. Did you want to contribute to candidates? Yes, in 2020, then more in 2021 and 2022. Why? I thought they could impact the world. Ian, you want to read some for a while?
Sure. Give me a second here. SBF, I was interested in pandemic prevention, so I thought policy was important. Congress and the executive branch, some were by FTX for cryptocurrency lobbying, some not most. Cohen, the crypto lobbying was for SBF, a U.S. regulatory structure. Now, it's interesting because he didn't want to go to the U.S. for the regulation, but now he wants regulation. Cohen, who else made donations? Nishad and Ryan Salame, or did you discuss them with Mr. Salame? He pronounces it Salam, so Mr. Salam. No. Your donations were from loans from Alameda Research. That's not great. Cohen, did you work with political consultants? SBF, yes, I had a full-time job, so I hired them. Did you know Michael Sadowski? SBF, he of guarding against pandemics. What about Congress members? I discussed crypto and other issues. Did you testify to Congress? Late 2021 and early 2022, and one in late spring, early summer of 2022. The House Financial Services Committee invited me. I declined. They invited more strongly, and I accepted. Like, what does more strongly mean? Did they send, like, leg breakers with a tire iron?
Maybe they sent embossed invitations. You know, like Count of Monte Cristo with the black envelopes. Fancy.
Fair. I'm just picturing something like the scene from, what is it? American Psycho. Where he's sitting there, like, admiring the card.
Mm-hmm.
Then agriculture about the CFTC. So then agriculture had a hearing about our application of the CFTC. Our competitors were in the AUSA says objection, no foundation. And that's sustained. New topic. Are you familiar with EcoSerum and SRM? Yes, I spoke with Nishad about it. I spoke with them about if our 2021 revenue was in fact over 1 billion. Why was that important? It's a round number. Why did FTX use Slack and Signal? They're conversational. What is encryption? It's like in World War II on the internet. It's only about the sender and receiver seeing the message. We thought it was good.
Not for nothing, but people have been trying to describe their messages long before World War II.
It goes way back to like systems where if you go back to like Roman era stuff, they had things like two different staffs that you would wrap like a message around so that then you'd read it top to bottom. And so you'd have to have a stick of the right diameter in order to read it properly. This is not a great system, by the by. Do you have a cylinder of the right diameter?
As always, the Caesar cipher, shift by 3.
Yep. All sorts of things which nowadays get cracked in about 0 seconds. Anything you can solve with pen and paper. Although the one that's actually fairly old that does work well is one-time pads.
Yeah, one-time pad is unbeatable.
Unbeatable so long as people don't screw up the one-time pads. Guess how often they get beaten?
By
Lots.
screwing them up pretty frequently.
Yeah, there have been lots of circumstances where one of the common things is people get lazy and they reuse the same page repeatedly.
Yeah, do you know what it's called? A one-time pad.
Yeah, it's right in the name, one time. But no, or they fail to destroy them. There have been plenty of times where they've just been like, they dig in the trash and they're like, oh, hey, here's a bunch of discarded one-time pads. That's not what you're supposed to be doing with that.
Yeah.
So, yeah. Where was I? Oh,
one-time pads are also really inconvenient because you have to have a secure channel for exchanging the pads. And if you have a secure channel, then to some degree you don't need the encryption in the first place because you already have a secure channel.
But you might have a secure panel at the beginning and not be aware if you're going to have it at the end. Yeah. So, you send your diplomat with a like with a one-time pad. And then later he can send messages back and it's all good. But the problem is that if somebody copies it midway through, then you're effed. So,
all right. For those in the chat who don't know what a one-time pad, I will now explain. It's actually pretty easy. So what you need to do is you need to have. I'll keep it simple. We'll just assume that we're just sending character letters. Okay, so the message is just going to be letters that spell words, right? So, but that don't necessarily have spaces. We're just sending letters. Okay, so let's suppose I just have a plain text message that says, I don't know, "Hello world," classic. Right, so my plain text message is "Hello world." So what I need is a random set of letters that's at least as long as the message I need to send. So "Hello world" is what, 10 characters? Yeah.
Yeah.
So I need at least 10 characters, and they need to be random letters. And then what you basically do is you just add the letters together. So H is the first letter, and let's suppose the first letter of the pad is Q. So you add H and Q and whatever that is, and you do that for every letter.
Basically, you convert them as per numbers, but you roll around on 26. Yeah.
Yeah. And then you can do it the other way around by subtracting the letter, and you get back the original message. The reason it's unbreakable, because as long as you follow the rules, there's no way to brute force it, because the message could literally be any message of that length. Because the key is random every single time, the message could be any message of that length. So there's no way to know what the message is, because there's no data from which to extract the correct message from other messages. There's no way to beat it. And but you need to follow these rules.
Often what you'll do as well is you'll just end the message with however many A's, so that you're always sending a message of 500 characters. There's no way to tell if this 500 character message is any different from any other one.
Right.
And if you really want to mess with people, you can just send a message. Like if you think there's somebody trying to decrypt, you can send messages for no reason. Just the only purpose is just that if somebody is sitting there intercepting your messages, because sometimes you can guess things based on how often a message goes out.
Well, that's what the number stations do, because the number stations regularly broadcast, and most of the time they're broadcasting nothing.
Yeah. So it's just like, hey, we're sending out a message, and the entire reason to send out a message is so you don't know when we're sending real messages. Spies are fun.
Spies are fun.
All right.
I studied cryptography quite a bit when I was undergrad, when I was doing computer science. I spent a little bit of my career thinking I might go in that direction. So I was studying like heavy math for a while before I decided to, do law instead. But yeah. So there was a time when I actually was good at math. It's been a long time, but there was a time.
And I am just a nerd who likes these kinds of topics, which is why I do the research on them. I do not like heavy math. I prefer that other people do heavy math because, oh my God, no.
Yeah. Anyways, the AUSA says, objection, who is we? SBF, I'm sorry, I mean me. I often say we, not to single myself out from other employees. What about record retention? Some we had to keep, some should not be kept, and then those in the middle. What about those calls? We had on Dan Freeberg and Brett Harrison. The judge, let's take our afternoon break. Cohen, Mr. Bankman-Fried, what about Celsius? Objection, sustained. In May to June of 2022, what did you observe? Objection, sustained. That's too broad. Calls for a narrative. You need to ask something a little bit more specific.
Yeah, you can't just ask, like, hey, tell me everything in the planet.
Yeah. What happened to Alameda in May 2022? Net asset fell from 40 billion to 10 billion by June 2022. Did you discuss hedging with Carolyn Nelson? Yes. What did you say to her? Alameda had assets of objection. The answer is stricken. It's just, what did he say? What was the substance of what you said? They had not hedged as of June 2022. Who else did you tell? Ramik, Ben, Sam Tribico on his way out. The conversation about mining firm. Who did you speak with? Ramik and Carolyn. I suggested Alameda be put on a $2 billion hedge. Did they? No. Again, if you want to put me on a $2 billion hedge, let me know.
You know what? I'll settle for 1 billion.
Yeah.
I'm going to be, I'm going to be generous on this one. I'll take 1 billion.
You're such a generous man. SBF. Carolyn approached us in the hut and said she thought Alameda had nearly gone bankrupt. I was surprised. How would you describe her demeanor? She was nervous. Objection? Overruled. What did you plan that day? To fly to DC, meet with senators and their staffers about a cryptocurrency bill. I put it off. Yeah, that's right, because he initially was going to appear at hearings, right? Before the Senate. That's right. Then what?
That's a great time to appear in hearings.
Nashid said there had been an $8 billion bug. It's a lot of bug.
Yeah, no kidding. Have you ever effed up coding so bad that it's $8 billion?
That's a lot of bug.
I feel like that should get you fired from like anything.
Yeah. I told them to fix the bug in the system underlying it. I thought they couldn't have been very robust if they allowed the bug. Was the bug fixed? Nashad and Adam, there was a memo. The memo not for its truth. Objection. 401. Not evidence. Nice. Cute. Not evidence. Or not relevant, at least. Did Gary and Nashad discuss the size of the liability? What I can say is, the judge, just answer the question. SBF, I don't recall that. When Alameda's liabilities came up again, what'd you do? I looked at Paperbird. Did the repayments on loans take place? Approximately $1 billion from Alameda. Did you speak with BlockFi? Yes, BlockFi is Zach Prince. We reached an option to buy them, and Celsius boards of directors. Then Voyager we provided a small amount. Let me show you this exhibit. Objection is only showing one tab. Mr. Cohen, please provide context. Cohen, you read my mind. The judge, no, I didn't. Cohen, did the topic of limiting what sent to the lenders come up? Leading. Did you have discussions with Mr. Yida about bulletproof? Yes. Do you recall where? No. Apparently, it was in the paddle tennis court hut. Okay.
I like how cranky this judge is getting.
Cohen, let's jump to August 2022. Did you have discussions with Nasheed Singh? Yes. Do you remember discussions of the Korean account? Yes. And did hedging come up? Yes, with Carolyn. Let's talk about things Sam was freaking out about. Were you freaking out? I don't tend to do much freaking out about, but I did start thinking about shutting down Alameda. There might not be the right management in place. Oh, your girlfriend wasn't as good as you thought when you initially hired her. She wasn't the one true source. Is that what's going on? Okay. All that good stuff. Sad. It is very sad.
I mean, she's had the worst breakup of all time.
She has certainly had a very interesting and lively breakup. Well, I cannot deny that for sure. Yeah. Thank you to Aussie J who give 5 gift memberships. KPT who gifted 5 gift memberships. Laura Leaney gifted 10 gift memberships. Baby Gator gifted 10 gift memberships. Laura Leaney then gifted an earlier 10 gift memberships. Sarah gifted $4.99. Spending the weekend in Las Vegas, now jumping in. Thanks for covering and making a perfect night, TGIF. Thank you very much. KPT gifted 5 gift memberships. Laura Leaney gifted 20 gift memberships. Fiona Duff W gifted 10 gift memberships. Ray Webb gifted 5 gift memberships. Baby Gator gifted 10 gift memberships. KPT gifted 5 gift memberships. Carol Blakemore gifted 10 gift memberships. Summer Butterfly's been a member for 10 months. Thank you for hitting the join button. Catherine Fraser's been a member for 12 months, and Mountain Princess 207 have been members for 12 months and 6 months respectively. Thank you for hitting the join button. Mountain Princess gifted 10 gift memberships. Lady Draconis gifted 10 gift memberships. Half Q's gifted 10 gift memberships. Yellow Pill 17 gifted $19.99 to say, please have grace for the triple ADHD shenanigans that made us late. I'll get over it. Mady Retmain said, if something was said in the hearing, could prosecutors use it to impeach him? Theoretically, yes, they could. Or is it all secret from the jury? Yeah, if he said something inconsistent, sure, they could impeach him with it. It's testimony under oath. Erilyn gifted 10 gift memberships. Yellow Pills $4.99 said, please have grace for the triple ADH shenanigans that made us late. So same message, but she gifted twice. So thank you very much for that. Halves Q's gifted 10 gift memberships. Petty Honest Throwaway gifted $4.99. Say you be the best. Sorry we're late. Matthew Felty gifted $10. Chris Mullen gifted 10 gift memberships. Contrarian 420 said Peter Thiel was an early investor in gummies. We had a story earlier about how women are apparently turning their placentas into powders that they then put in capsules that they then swallow and or turn into gummy form. And there are apparently several businesses that will do this for you.
As gummy. Why?
I don't know.
Like, what do they advertise this as?
Some sort of woo-woo thing.
Okay. So it's just like, hey, have you ever wanted to eat?
Have you ever wanted to do auto cannibalism?
I mean, who hasn't?
Tasha Lynn gifted 5 gift memberships. Yates Network became an uncivilian for 99 cents. Veronica has been a member for 99 cents for 8 months. Thank you for hitting the join button. Patricia Del Bill gave 24 Canadian dollars, I think, who gave me a peach looking at a mirror saying thanks for being you. That's very nice. Tony B gifted 10 gift memberships. Nick M has been a member for 7 months. Thank you for hitting the join button. Angie Torres has gifted 20 gift memberships, and John McGrave has been a member for 12 months. Thank you for hitting the join button. I believe I am now completely caught up on all the super chats. So thank you to everyone who did all those things. I appreciate all those people. You all kick ass. Thank you for your support and your tolerance of everything as I continue to try to give you good quality content.
And succeed.
Let's see. Colin Cohen said, did there come a time when Nishad spoke to you at Orchard? Yes, Nishad expressed concern about marketing brand partnerships. I told him the marketing team was a mess. I said didn't do green light certain marketing new initiatives. I told him other initiatives were succeeding, like MLB umpire patch. How did Nishad seem to you? I experienced Nishad as nervous and halting. Your Honor, this might be a natural baking place. Okay, we'll see you Monday. The jury leaves. Mr. Cohen, we should finish Monday by 11:30. The AUSA says we intend to cross. The AUSA says I don't think anyone would benefit by a day and a half across, but it might go into Tuesday and a rebuttal case. Closing 2.5 hours, 2 to 3 hours in rebuttal. Same. That's a long close. 2 to 3 hours is a long close. There should be a law against that, to be honest. Then the charge. So the jury Thursday or Friday? Agreed. Or even Monday. Should we set a charge conference? Not until the fat lady sung. I'll tell you, have a good weekend. And that apparently is all there is for that. So yeah, things are going just about as well for FTX as you could possibly imagine. It's going super duper great. So he's going to be in jail, very, very soon.
And for the rest of time.
Yeah, for sure.
Because screw that. I mean, the thing is you typically don't want to call your client. This is just a general rule of defense practice. You
Yeah.
don't want to call your client because your client almost always sucks. And I don't mean that like necessarily as like your client is a bad person. I just mean your client doesn't. It's probably their first time testifying, right? And clients usually screw things up. So if you can avoid calling your client, you probably want to do that. So sometimes you're in a position where you have to because like the nature of the charge, right? Like if it's a self-defense case, you might need to have somebody testify that they're in danger, right? Um or sometimes you just think you can't win without your client testifying because you are so screwed that like you got to pull a rabbit out of a hat. I think they're in rabbit out of a hat territory here. And yeah, that's a bad place to be.
Yep.
So ugh. I think that I think they're probably preparing SBF for like, hey, get ready, you're going to jail.
Yeah.
So
I think he's realistically facing jail. I forget what the formal amounts are, but he's realistically facing jail for the rest of his life.
and I mean,
And
good.
he'll probably get it. He'll probably get close to it. He'll get a couple decades behind bars. But yeah.
I think he really should be there for the rest of time. So
Yeah, for sure. Well, it's 1:30 in the morning. I think I have some other stories in the queue if you want to do some more, or what's your pleasure?
I'm game to keep going. Unless you're wanting to get rid of me, I'm good to
No, if you leave, I have to be alone with my own thoughts, and it's scary for me.
that is fair. I don't have anything I got to wake up for tomorrow. So, yeah, I'm game to, hang out.
Cool. Let's see
It's
what's else. Let's see what else we have left on the queue.
yeah, I was sorry I couldn't join in on Thursday. My dad's in town, so sort
All
of
right.
juggling all of that.
You never owe me
No, but I like hanging out.
unless you make a promise to me, like Rob.
I like hanging out.
But otherwise, you don't owe me.
I just like hanging out. That's
Yeah. Let's see. All right. So Donald Trump is going to apparently testify on November 6th in the New York civil fraud trial, so we can cover that for a hot minute.
Oh,
and his daughter is also testifying.
Yeah, I was going to say, isn't Ivanka also having to testify?
She sure is.
That's going to be exciting.
Who Donald Trump once said that he would sleep with if it wasn't his own daughter, which is an interesting comment.
That's a hell of a comment to make about your own daughter, because most people would not make that comment about their daughter. I mean, I guess it's good that he doesn't want to sleep with her right now, but still, ew.
Yeah. Donald Trump apparently is going to take the stand in his civil fraud trial, which I need the transcript of this on so many levels. For sure. Yeah. There's no way this ends well.
Yeah,
his 3 eldest children are also taking the stand in a case that threatens to disrupt his family's real estate empire. Yep, his businesses are going down hard. It was already expected the president and his sons would be testifying. The timing became clear on Friday after the judge ruled the daughter must also appear, rejecting her bid to avoid testifying. The schedule sets up a blockbuster stretch in the trial of New York Attorney General's civil lawsuit. She alleges that the former president, now the Republican frontrunner, overstated his wealth for years on financial statements that were given to banks, insurers, and others to help secure loans. And we've read some of the judge's summary judgment on some of this already. And yeah, it appears that many of the numbers were significantly inflated. And while there's room to criticize the judge as to parts of it, I think it's difficult to criticize the entire overall conclusion. So,
And this is one of those cases that's kind of hard to cover because a lot of people get really upset when you're like, well, guy you like might be in some trouble, because they people get really territorial about this stuff, but it's not about that. It's about just like, what does the evidence show? What does it not show?
yeah. Donald Trump and the two defendants are defendants in the lawsuit, but the state is initially calling them in their own case in chief, which of course it's a civil case, so you can do that. Donald Trump also testified on Wednesday in answers to questions about whether or not he should be held in violation of the court's order for its gag order, and then fined him when the judge said his testimony was not credible. So they fined him $10,000 on top of a $5,000 fine earlier.
That is not where you want the judge to be finding midway through the trial.
Not really, no. It's not great. Donald Trump Jr. set to testify on Wednesday, the brother on Thursday, and the sister on November 3rd. The lawyers may try to appeal, but good luck. An appeals court dismissed her as a defendant in the lawsuit in June, stating the claims against her were too old, but that doesn't preclude her from being a witness. So she might not be able to be charged herself or sued herself, but that doesn't preclude her from being a witness in someone else's case. Ivanka Trump had announced in January 27, ahead of her father's inauguration, that she's stepping away from her job as executive vice president of the company. She soon became an unpaid senior advisor in the White House, then moving to Florida. Her lawyer told the judge that the state's lawyers just don't have jurisdiction over her. And I don't know about that, because I think some of these things go back quite a while. So I don't know about that. One of Donald Trump's attorneys said that the state lawyers just want to know free-for-all on the Trump children. Well, I mean, they are all entangled in the business.
Yeah.
So they're all valid witnesses as to the Trump organization. So, you know.
That's the thing, is if you make your family members like directors and whatever else in your company, then yes, they will be valid witnesses to stuff that happens in the company. Like, that is just basic stuff.
Yep. The idea somehow is that Mrs. Trump is under the control of the Trump organization, or even the defendants, her father. Anyone who raised a daughter past the age of 13 knows they're not under their control. Well, again, if they're in the business as executive vice president of a company, then yeah, I mean, you know, duh. I mean, yes, she's under their control because he outranks her in the company. I mean, that's on the nature of the thing.
Can he fire her?
Yeah, exactly. Can he fire her? However, state's lawyers argued that Ivanka Trump was a key participant in some discussions, and the case remains financially and professionally intertwined. The judge sided with the state, citing documents that showed that Ivanka Trump continues to have ties to some businesses in New York and still owns Manhattan apartments, which probably gives Impersonating jurisdiction as well, because she lives there. Ms. Trump clearly has availed herself of the privilege of doing business in New York, said the judge. During her years of the Trump organization, Ivanka Trump was involved in negotiating and securing financing for various properties, including a lease and loan for a Washington hotel and loans for Trump's Doral golf resorts near Miami, and a Trump-owned hotel and condo skyscraper in Chicago. According to the New York Attorney General's office, Ivanka Trump retained a financial interest in the Trump organizations even after leaving the White House, including through an interest in a now sold Washington hotel. That's sad that they sold that hotel. That was actually a really nice hotel that they built in DC. It was the old post office. It was a very historic place, and it was a really nice hotel. I had lunch there once. It was really nice. In court papers, huh?
I've never been. I mean,
In
I
court
imagine it'll
papers,
probably continue to be a nice hotel. Nobody's really going to buy that just to like tear it down.
yeah. In court papers that include emails and other documents, the state lawyers said the Trump organization and staff also bought insurance for Ivanka Trump and her businesses, managed to have her household staff and credit card bills, retain an apartment, and pay legal fees. In 2011 federal disclosures, she reported $2.6 million in income from Trump entities, including revenue from a vehicle known as TTT Consulting. A company bookkeeper testified TTT was set up for her and her brothers to reap share of licensing. Yeah. So I think this makes logical sense. She seems like she's involved enough to be a valid witness for some of these things, at least during periods when she was more involved, if not even now. So I
Yep.
think that this makes logical sense, at least based on the article, about why she's a witness here. So I'm not surprised by that.
I don't disagree. I mean, I think that they're it's not like a crazy thing to bring them in, and I know it's not going to be popular with some people, but like she seems like a genuine witness on this. So
Yeah, I mean, I always try to adjudicate things as fairly as I can, as ever, and try to just give an honest and fair assessment of where I think various things lie. And, that video that I recently did about the Trump case and the Rico, Georgia case, I tried to be fair. I got accused in the same comment thread in that video about both simultaneously crying because Trump is getting convicted, and that makes me sad, and also having Trump derangement syndrome. So I apparently made everyone unhappy simultaneously.
that's always fun when you've got people. I did a video recently about police shooting, and I've got people in the comments going, "You're just a shill for the cops," and also, "You're not being fair to the cops." And I'm like, which is it?
Yeah, it's a strange thing. It's a strange thing. It's like there are a lot of and the one that really, like, where the chat and I have had like the strongest fight is like on the classified documents case, because the chat and I have had some interesting fights from time to time, because some people in chat so desperately want to find a reason that Trump isn't guilty or something. It's like they're really stretching things so far, and I just have to keep telling them, no. It's like none of these things, and they're so desperate. They come up with these convoluted theories, convoluted facts, or convoluted law, and I'm like, no, none of these things. It's like,
Yeah. It's like, no, this is not how this works.
Not how this works. It's like, so anyways, this was a pretty interesting story. A state level senator for the state house in Washington was arrested in Hong Kong for carrying a gun through the airport. Oops.
Oh, I saw that one, and I was like, wow. Although I got to give him some points for being a little more honest than I might have been. Because if I found that I'd brought a gun accidentally, I probably would have been trying to get rid of that thing in the like trash or something.
Trash. You just throw it in a trash can and hope no one notices. Yeah.
Like just take it apart and throw the bits away.
I think there for sure. An American politician has been arrested in Hong Kong for carrying a gun in the city in what he calls an honest mistake. The Washington state senator was arrested Saturday at Hong Kong International Airport and charged with possession of a firearm, which is punishable by 14 years in prison. Yeah. Wilson appeared before the magistrate. $2 from Matthew says the syntax of the Trump article is weird. You'd have to ask the AP who wrote it, at least according to them, but yeah. So, but I appreciate the super chat. Thank you very much. Wilson appeared before a magistrate and was granted bail. The Republican state senator, whose full name is Stephen Wilson, says he didn't realize he packed his pistol in his briefcase. when he and his wife were traveling to a 5-week vacation in Southeast Asia. How did he get through airport security with it?
I have no idea, but I'm impressed.
It was an honest mistake, and I expect the situation to be resolved shortly. He said he
I gotta-
discovered the weapon mid-flight between San Francisco and Hong Kong. At that
I've got
point,
another
I'm
question.
desperately looking for the plane's, trash, or can I stuff it into the trash of the plane or something?
I'm
so
probably
that
not thinking like the plane's trash. I'm probably thinking like the airport. Like get off the plane, go to the bathroom, like just, that's kind of my thought.
Yeah.
Because yeah. But I mean,
He didn't realize the pistol was in his briefcase when he passed through airport security, and baggage screeners failed to notice it. Yeah.
Some baggage screeners getting shit canned.
Wilson said in a statement that when his plane landed in Hong Kong, he immediately went to customs and called the attention to their issue. In email reply to CNN, a spokesperson for TSA said that TSA is aware a passenger on a flight departing from Portland passed through security and traveled with an unloaded firearm in his carry-on bag. TSA apparently takes the situation seriously. The penalty for carrying a firearm to TSA may be as high as $15,000. Yeah, his problems in China are a little bit richer.
Yeah. Ooh.
So the penalty for bringing the firearm to TSA is $15,000 and no TSA pre-check for 5 years. Your penalty in China is go to prison.
For what was that, 15 years max?
Yeah.
I feel like that's worse.
14 years.
Oh, 14. Yeah. We got to be really particular on that one.
The U.S. consulate says they're aware of reports of no further comments. Hong Kong has no further comments. Yeah. Yeah, good luck on this whole thing. Under Hong Kong strict gun laws, no one's allowed to possess arms or armor unless they have a firearms license, which are only given to police officers, armed security guards, and operators of exclusive shooting clubs. In Washington State, open carry is allowed for both long guns and handguns. However, a license is needed for concealed carry. And he does apparently hold a concealed pistol license, which may also be in some jeopardy, potentially, in Washington.
Wow, he's have they let him fly back, or is he being held?
He's being held there in China for the moment. And I don't know that he's coming home, man. He's now a diplomatic football. And relations between China and the United States are not exactly super wonderful right now. So, yeah.
I was just thinking that, like, this is not a great time to be getting into that kind of dispute. So
China's going to want something for it.
Yeah, I suspect that this is going to get resolved in a way that would not be available as a resolution for you or I, which is...
You and I are being hosed.
Oh, yeah, we'd just be getting jail. Whereas I suspect he's going to get some offer of, like, if we get something we want, like, under the table, we will just drop the charges and give him a very stern warning not to, not to exist.
Mm-hmm.
I'm guessing he's probably lost his China privileges as well.
Yeah, no joke. New York City apparently has given up on the migrants. They declare themselves to be a sanctuary city. They said, we love the migrants and we love them and we want to give them free housing and free everything. And now they'd like you to please leave. So they got what they wanted, and apparently they don't want it anymore. So they're offering migrants one-way tickets out of town. That's just hilarious to my mind, because it's just the Schadenfreude is so really real. It's the whole Schadenfreude of the thing. It's like, Texas is so mean. The United States is so mean. Why do they want to deport all these illegals? We're a sanctuary city. Come here. Be here. Now they're like, please don't. We can't support them. And Chicago's doing the exact same thing right now. There were protests in Chicago along these exact same lines. This is pretty funny. New York City is intensifying efforts to transport migrants out of the city as its shelter system reaches capacity. setting up a dedicated office to provide asylum seekers with free one-way tickets anywhere in the world. Ooh.
Really? So they can be like, I'm going to Disneyland?
Maybe Disneyland will take them. City Hall confirmed the establishment of a new reticketing center in Manhattan as the latest bid to ease pressure. They could just admit they were wrong. That'd be good.
No, they were just temporarily less right.
The mayor, who is a Democrat and also a MAGA supporter, I guess, has described the situation as a crisis and began to warn shelters are so full of migrants, they'll soon be forced onto the streets. I can't say it enough. We're out of room. It's not if people will be sleeping on the streets, it's when we're full capacity. Oh my God. They can't support the people. Oh no. The city's plan to offer migrants transportation builds upon previous efforts to send asylum seekers elsewhere, though the establishment of a dedicated reticketing center marks a renewed emphasis on it. It is, at the moment, voluntary.
At the
mayor's
moment.
office recently limited adult migrants to 30 days in city shelters and 60 days for migrants with children. Migrants, most of whom work without legal ability to pay, can reapply for housing if they're unable to find a new place to live. But how could they? It's New York. It's kind of pricey.
Yeah, I feel like New York rent is is going to be a challenge.
Yeah. Adams is also seeking to suspend a unique legal agreement that requires New York City to provide emergency housing to homeless people. So they codified it into law. They codified a right to housing in law. We are such a tolerant city. We believe that every person has a fundamental right to housing. And guess what? People took them up on the offer. Yeah. No other major U.S. city has this requirement. The mayor's office is arguing in court the mandate was never meant to apply to an influx of migrants. Well, anyone could have seen that coming. It's like, yes, we will guarantee housing. Everyone has a fundamental right to housing. We will guarantee housing. Wait, this wasn't meant to attract people to the city, to take advantage of this.
I mean, if I was homeless anywhere, I would have been like, New York it is. New York, New York.
Get myself a Greyhound bus, man, and just, take that, man. No big deal. A judge this month directed the city to enter mediation discussions with homeless advocacy groups to find a solution. The mayor's office says it's rushed to set up more than 200 emergency shelters to house migrants, including renting spaces in hotels and erecting large-scale facilities. 65,000 migrants are in city facilities. Adams says the influx is expected to cost $12 billion over the next 3 years. They're eating it. They're eating it hard, and I'm here for it. I'm here for the Schadenfreude. Just admit you were wrong. Just admit you were wrong, and that the people of Texas weren't just racist bigots, and they've been dealing with this problem basically forever. And you thought, and now you have this whole stay in Texas thing. You want it to be Texas's problem. It's really what is it that's saying? The problem with socialism is eventually you run out of other people's money.
It is true.
Yeah. So,
of course, same problem with capitalism, but
well, no, in capitalism, you create new money. Like you can create money that wasn't there before because you create a new thing and there's new money because you grow the pie. Right? No?
Indeed.
Okay.
I mean, in theory, the same thing can happen. It's just in practice, people don't really want to work hard if there's no prospect of reward for it.
Right. That's why socialism
apart.
or communism doesn't work because there's no incentives.
Things fall apart. Yeah.
All right. In bad makeshift repairs, Tennessee man with the makeshift repairs apparently was so bad, people confused it for a explosive device. He had makeshift rubber bumpers that sparked a car bomb panic with a massive response. And this was all so yeah, Tennessee man tried to bodge his car and apparently bodged it so bad that people thought it was a car bomb. And here apparently is a picture of the car that he now I'd like to take note, by the way, I'm not an expert on car bombs, but my general understanding of car bombs, and please correct me if I'm wrong, aren't they supposed to be like relatively innocuous so that you can't see them?
That's
So that when you
usually the
get
goal.
into the car and you turn on the car or press the cigarette lighter or turn on the radio or whatever it is it does, it explodes. So you can't readily see the car bomb. Who builds a car bomb that's readily obvious?
The world's worst assassin. Is this a picture? Huh.
Yeah.
You know what? I might assume that was suspicious as too. Because to me, that looks like somebody's tried to... I'd be worried that somebody's trying to build some sort of like Claymore apparatus and stuck it to the outside of their car.
Officers were called to Murfreesboro, Tennessee over the seemingly explosive device after calls about a car appearing to have a bomb strapped to its side doors. Sitting outside First Watch Restaurant and Medical Center Parkway, the car had wires connected to suction cups on the inside of the door handle. Apparently, federal, state, and local officers responded to the threat, and all businesses in the shopping plaza were evacuated for 2 hours. Schools in the area were placed on lockdown while investigation was ongoing due to the address associated with the vehicle. After some time, the police department reached out to the owner by phone. He was standing with other evacuees across the street the entire time, unaware that it was his car that promoted the threat. So he's just standing there across the street. It's like, yeah, what do you want? Yeah, calling about your car. Oh, yeah, that's my car.
He's like, man, who's the ass? And it's like, oh.
The Tennessee Highway Department responded and gave all clear after examining the car. Since there was no intent to cause harm, the police department said the man will not be charged. So maybe design something better next time, my friend.
This is hard mode. Am I the asshole?
This is hard mode. I am the asshole for sure. I like that very much. Yeah. Oh, man. How's your channel been doing lately?
All right. I mean, it's always hard to judge, right? But
how's your subscriber count been on the last year?
A little bit of growth. So, I mean, I haven't sort of hit anything that was like the depth trial or anything where there's like a big, you know, where there's like a big boost or anything, but it hasn't been terrible. So, I mean, I can't complain too much. Some people have really, really struggled, but it's always tough.
I've been pretty flat for the last year.
Yeah, I mean, more or less, but I mean, I make videos sometimes where I'm just like, this video is going to suck. I did a video on a complicated question of like jurisdiction between the federal and state governments in Canada. And I was like, this video is gonna bomb. But somebody asked me to do it, and I was like, fine, we'll do this video that no one will want to watch. And it ended up being like a #1 video. And then you do a video where you're like, everyone's gonna love this one. This one's gonna go and, you know, do some numbers. And it's like 10 out of 10. You're like, but why?
I've had that happen more than a few times. I can't determine it.
And like, you work really hard on the thumbnail, you post it at like the absolute perfect time, you're thinking, and it's just like 10 out of 10. You're like, why? Also, they age restricted my video on the that shooting in this the Leonard Cure shooting.
Mm-hmm.
And that one just annoys the hell out of me because there's all sorts of news organizations who have that video up just as is, no editing, you know, whatever else.
Mhm.
Meanwhile, I put it up and I actually blur the moment of the shooting, and
Mm.
they're like, "No, this is improper. We're you know, we're age restricting this." And I'm going, "Come on." So, I don't know. It's hard to understand. Oh, and I put in an appeal for it. I was like, "No, this is like you've got this allowed on other channels." They rejected my appeal in about 4 seconds. Like, it was literally just submit appeal, and then I get an email saying your appeal has been rejected. And I'm going, "You didn't even have time to find the relevant section of the video." So, like, I don't understand how you could reject my appeal. Um, like, how? But
Have you? Do you have a YouTube? You must have a YouTube partner manager. Have you ever found them to be useful? I have never found mine to be useful.
I've had like 4 of them because they keep scheduling me people who are like, I have appointments at like 2 a.m. I haven't really talked to them. I spoke to them like once, and
Yeah.
we had a meeting where they're like, "Have you tried posting good videos?" And I was like,
Yeah, it's like this is very generic
"Ye-
advice that is completely non-actionable. Have
yeah." I
have
was
we
like, "I
talked to you
have
about
indeed."
shorts and how shorts are good? I'm like, I don't know how to. Yeah, this is non-actionable.
Yeah, I mean, I like the idea of shorts, but how do I make them not suck? Because when I post a short, it gets about the same numbers as my regular videos,
Yeah,
and except on the money, because on the money they do terribly. You've got to
I
get
just
like a
use them
hundred.
as an advertising tool to hopefully drive traffic to my channel. I'm not sure how much it helps, but that's what I'm trying to do.
Yeah. If you get like 100,000 views on a short, you make like $1. Which I mean, shorts
Yeah,
are a lot of work to make. So
yeah, they are.
you'd think, oh yeah, it's just a minute. So like, how hard can that be? And it's like, it can actually be really hard to be really on point and concise and for that minute. So
All right. Well, I think I'm officially beat.
all
I'm
right.
tired.
Well then I will let you go. Um, thank you for having me on. It's always a good time, and those are some fun stories.
Well, we aim to keep things fun, and we tried to cobble together some stories so that we'd have some fun stuff for the people to join us and have a good time. So I appreciate it, and then I'll try talking to Rob tomorrow or something and see if we can clarify what happened. Because yeah,
Yeah, I don't think that there was anything intended by it. I think he was just having trouble with because he was, after the stream, just in the back room. He's like, I can't get the freaking you know, redirect to work. I'm like, no, that's not good.
it should
So
just be like automatic because you just go into YouTube and I mean you know how to use it. Go in back end customization, redirect. You put it in there, right?
I was trying to redirect something to Rob a bit ago, and it was not recognizing his channel. And like his channel was, is on my list of like approved redirect locations. It just wasn't showing up. And I was like,
Hmm.
so
Yeah, and you have to set up that redirect before you're on the stream. Once you're on the stream, it's too late.
yeah, and YouTube is like miserable for all of that shit. So,
Yeah. All right. Well,
but
I'm going to let my guest go, and when you're on Monday, give me a call and we'll hang out.
sounds good. Have a good
All
one.
right. Well, thank you, Ryan.
Night.
All right. All right, guys. I'm going to go ahead and sign off myself. It's been on civil law. I've had a lot of fun. I hope you've had some fun too. And sorry I was a little bit grumpy earlier. Um, it's always challenging. It's always challenging to know how much to share and what to share. And I thought not to, and I thought whether I should or not. But people asked, and I was like, so I shared, and then people were upset that I shared, and people were like, it's always a weird thing. And perhaps it's my fault for sharing it all. I don't, honest to God, know sometimes what people want from me when it comes to these things. I really don't know, but perhaps it was my fault at all. But I was frustrated. I was frustrated because, you know, I had asked Rob up front, you know, what time the redirect should be. So I knew when to schedule it. So I scheduled it when he told me to. And because I asked him in advance, like what time. And then it was 2 hours later. So I felt a little disrespected because, you know, it's like I had what I thought was an agreement, and then the redirect didn't work. And that was upsetting because I was really looking forward to getting all that traffic. As I'm sure you can appreciate. He had like something like 6,000 people watching. I was like, you know, I was really looking forward to getting all that traffic. And so it sucked the sales right out of me. So, but that's just the truth of the situation. And so, yeah, so that's what happened, in case you care. Yeah. Yeah. And Rob is my friend, obviously. So it's not like I'm going to have some sort of like, you know, I'm not going to hold a grudge against him or anything. It just was upsetting in the moment because it didn't work out like I had hoped. You know, I was really excited because I was really looking forward to all that traffic, and you know, I was ready to go 2 hours in advance, and it just seemed a little disrespectful, you know, because there didn't seem to really be any effort to try to get things done. But I'm not going to hold a grudge against him or anything. It's not a big deal. Yeah. We're friends. Our friendship will survive this. I mean, it's not that big a deal. Just a little upsetting in the moment. On Monday, hypothetically, I'm going to have a video posted about Maya, in case you guys care about that. Um, Trying to talk on the situation a little, so we'll see how that does. I did some research earlier today, trying to figure out how to cover the story, and I think I covered it from an interesting angle. Um, so hopefully on Monday that video will post. So we'll see how that's going. Um, yeah, I'm tired. The Maya case is heartbreaking. Yeah. Any particular focus on my case? I gave a background mostly from the medical perspective of the case of Maya, trying to give a background of sort of how Maya's case developed medically, and um, trying to talk about how the situation developed from her initial diagnosis. Well, first of all, I went even first before that. Like there's a length of time in which she's not being diagnosed, and then she gets the diagnosis. Then she gets this doctor who's prescribing this ketamine coma therapy, which is controversial. Uh, Maya's parents start to get some uh, problems relating to that before they ever get to John Hopkins. You know, there was some pushback because this treatment was uh, experimental at best, and very controversial. And so they were getting pushback even before they went to John Hopkins from family members and other doctors and their community and stuff like that. And so John Hopkins in some ways was the I've done ketamine I've done ketamine intramuscular for major depressive disorder. Leon, I found it very helpful. I hope you do too. Recommendation: I don't know if it is similar for intramuscular as it is for nasal, but I'll give you a recommendation. My recommendation is wear an eye mask and get some noise canceling earphones and listen to affirmations when you're using the ketamine therapy. That's what I did. Worked great. Right. So block out the light, block out the sound, listen to some affirmations. Fantastic for the ketamine therapy. Anyways, so then they go to Johns Hopkins and they have this doctor, Dr. Smith, who seems to be the central focus, at least to her, to my mind, who believes that she diagnoses. Do I have to go to a center? Yeah, I went to a doctor's office. So yeah, I suppose it wasn't at my house, if that's what you mean. Yes. Um, uh, so they go to Johns Hopkins. Dr. Smith is the principal person who believes that this is Munchausen's. And then you know, basically that she thought she'd be the hero, but she winds up being the villain. And you know, kind of approaching it from that angle. Um, so that's how I approached it. I actually, in my script, never mentioned that Maya's mother committed self-deletion. So I cover it. I decided to cover it from the sort of the medical history angle, and that's how I wrote the script. So that's being edited, and hopefully we'll post on Monday. Did the ketamine help me with my depression? Yes, I found it by far and away to be properly the singularly most effective thing for depression. I think at some point I'll try it again. But I found it to be, also, pro tip, again, I don't know if it's the same with nasal as intramuscular, but Zofran for nausea was the major side effect for me. They did not give me Zofran the first time I went. It made me quite nauseous. So every time I went after that, I made sure that they gave me Zofran for nausea. So recommended. So Zofran for anti-nausea, eye mask, noise canceling earphones, affirmations, and relax and allow your mind to wander. Just try to roll with it, roll with the roll with it, roll with the waves. Because I found that I can, if I concentrate, kind of beat the ketamine, but then that kind of defeats the point. Like, so kind of let yourself go and just ride the waves. Don't think. Observe without thinking. Think you haven't been anxious about it? You shouldn't be anxious about it. Yeah, I don't think there's any reason to be anxious about it. The best way I could describe what it was like would be like it would be like free association in your mind. Um, the best way I can describe is it disassociating. Here's how I would describe it. Here's how I describe how it was for me. Suppose I asked you to give me. Suppose I said a word, and I asked you to tell me the first word you think of. So if I said day, you might say night. Okay. But all right, now instead of telling me the first word you think of, use that word as the leaping off point for the new word. So like you do 2 steps removed, right? So day becomes night, becomes moon, maybe, right? Because that's 2 steps removed, right? Day makes me think of night, and night makes me think of moon. So if I say day, you say moon, right? Now do 3 steps. What makes you think of what makes you think of what, right? So day makes me think of night, makes me think of moon, makes me think of dancing, right? So if I said day, you say dancing, right? So what I found for me is that basically it was like it created it, basically my thoughts would leap from instead of being linear, right? Instead of like being a story that would be linear, um, it would jump. It would jump in a way that made sense, but it would jump like 3 steps up. So the things that would make me think of, right? The things that would make me think of in my mind, the associations in my mind were much more um um the associations in my mind were much more free. How was long was the effect? Um about 40 minutes maybe, give or take, to varying degrees. It's fairly, at least in my experience, it was fairly quick onset. Um, so ADHD thought process, something like that. Yeah, yeah, something like that. Yeah. So I found it created, at least for me, I found it created a lot more like a web. My mind was like webbing. Like I could feel it like, uh, yeah. Is it scary? No, it wasn't scary. It was different. That's for damn sure. I never really had any experience like that. It was very different. It helped my depression for a week or a month. Um, mm, I was doing it every week for 12 weeks. I found it effective for the 12 weeks that I was on it. Um, I think that's the most honest answer I could give. Um, would I ever do a K coma? Probably not. That sounds like a lot. Yeah, that sounds like a lot. No, probably not. Uh, yeah. Ketamine itself tended to wear off completely by about 2 hours, maybe. I wouldn't recommend driving immediately following it. Um, but that's only my experience. I think I can't really say that my experience is typical in any sense. But I found it effective and I recommended. It was like listening to a comedy routine with nothing but punchlines. No, I wouldn't say that at all. Yeah, doctor have to stay 2 hours. Yeah. I used to get an Uber when I went home. Um, but yeah, wouldn't recommend driving right away. First time you do it, uh, you might not have an appetite for a day. But then again, that could have been because they didn't give me the Zofran the first time, so that could have been a problem. Um, yeah, I think I'd recommend it. I'd recommend it. Um, I considered it to be a positive experience. I consider it to be a valuable experience. It's certainly something I would do again. Um, I recommend it. Um, and that's all I have to say about that, really. Diet changes are hard. Diet changes are hard. I have food addiction problems. So changing my diet is a lot easier said than done, unfortunately. If I could change my diet, I probably wouldn't have these problems in the first place, to be quite honest. Yeah, but I don't think you have anything to be afraid of. Um, I don't think you have anything to be afraid of. Get the Zofram. Get the Zofram. Get yourself a sleep mask. Get yourself some noise canceling earphones. Find some good affirmations that you like. Put those on and relax. You'll be fine. Yeah. And also personally, on a personal level, because I imagine it's I imagine it's I don't know, but for nasals the same, but for IM, they monitor your blood pressure because ketamine, at least intramuscularly, apparently really should ship your blood pressure a lot, and they won't let you leave until your blood pressure like drops to like 10% above normal or something. So my personal recommendation is when they do the blood cuff, make them leave it on because when they come in like 20 minutes or whatever it is to put the blood cuff on again, to monitor your blood pressure. It's a little distracting, you know, with them putting on the blood cuff because I'm trying to ride the goddamn wave. You're messing with my wave. So if they check your blood pressure, which I imagine they're going to do, ask them if they can leave the blood cuff on the entire time. Because that way, when they come back, all they have to do is press the button or whatever. They don't have to put it back on again, which is a pain in the ass. Well, that's a personal pro tip. Just leave on the goddamn blood pressure cuff. So when you come back in 20 minutes or whatever, it's already there and you don't have to fuss with it and you don't have to fuck up with my wave. God damn it. Don't have hooked to a machine or a timer? No, because they monitor it in person. They monitor it on person. I'm going to sign off now. Good luck with the ketamine therapy. I'll talk to you guys. Until there, my friends, I hope all's well. Cheers, my friends, and goodbye.